accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. My name is Larry Clay and I'll be chairing today's session. Panel members today are Dino Lombardi, Katie Plaitzer, Phil Gosh, and Ryan Bissonette. Our Deputy Secretary Treasurer today is Sabrina Salatino. We acknowledge the land we are meeting on is a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some applicants and participants will make their submission in person, and others will participate virtually by electronic means through WebEx. The meetings are also streamed on Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. For those participating virtually, when your item is called, you'll be unmuted by the moderator. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. People attending in person today who want to receive a copy of the decision of the committee must first fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies are permitted to appeal decisions of the Committee of Adjustment. Today I'll call each item in the order listed on the agenda, and where an application is contested, the agent or applicant will proceed with their presentation. When an application is uncontested, the committee may not require a presentation. The committee may ask questions and or take the matter into committee for a decision. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept new materials at the hearing. The applicant or agent will proceed first and make a presentation to the committee, and then individuals either in support or oppose the application will be invited to speak. Generally, we call on speakers in the hearing room first and then those participating through WebEx. Each speaker, including the applicant, will be given a maximum of 5 minutes to address the committee. I will comment when you're reaching the 5-minute mark. When all speakers are finished, the applicant or agent has an opportunity to rebut those issues that were raised by the speakers. This will mark the end of the discussion, and the application will be taken into committee for a decision. Madam Deputy Secretary Treasurer, are there any minutes to confirm?
Good morning, Mr. Chair and panel members. Yes, the November 26th hearing, those minutes are ready for adoption.
Okay, I will move adoption. Can I have a seconder? Phil, Mr. Ghosh, all in favor? Those are adopted. Are there any declarations of interest in this morning's session? Panel staff, see none. Any files to be closed today?
Through you, Mr. Chair, yes, there is one file to be closed. Municipal address 623 Broadview Avenue, file number A0755/25TEY. The landowner no longer wants to pursue this application.
All right, I'll look for a motion to close that file. Mr. Lombardi, second by Ms. Plaitzer, all in favor? That is closed. Any deferral requests for this morning?
Through you, Mr. Chair, I don't see any deferral requests from agents this morning.
Okay. All right, then we can proceed with our agenda. We'll open with number 199 Whitehall Road. This is an application to construct a new 2-story detached dwelling with a front integral garage, a front covered porch, and a rear ground level terrace. Also to reconstruct the driveway abutting Whitehall Road. Committee has before it the copy of the plan of survey, site plan, floor plans, and elevations, covering letter from the agent, previous decision number affecting the subject property, correspondence from the architect. We have an arborist report, and a heritage impact assessment, and presentation materials from the agent. We have staff reports from urban forestry, heritage planning, community planning, and transportation review. We have an advisory report from urban forestry as well. We have correspondence in opposition from 72 and 89 Douglas Drive, 102, 100 Douglas Drive, 97 Whitehall, 60 Douglas Drive, 103 Whitehall, 96 Highland, and the North Rosedale Residents Association. Do we have our agent here or online? Oh, here. Good morning, sir.
Good morning.
Name and address, please.
Yes, Kevin McCrow, agent for the applicant. I'm a senior planner with W&D Associates. Address for the record, 47 Roselawn Avenue, Toronto, postal code M4R185.
That's great, sir. Welcome. We do have some folks who want to speak to this item, so we'll need a presentation.
Sure, thank you.
Do you have a presentation?
Thank you. Yes, I do. I did submit that in advance, and if I could ask staff to please put that up on the screen, I'd appreciate it. As I go through this, just for the staff, I'll be pointing perhaps to some page numbers, so just to kind of transition between the slides, or I'll indicate next slide or something. Thank you. All right, this is an application for a proposed new dwelling at 99 Whitehall Road. The application will also include demolition of the existing dwelling and the existing detached garage. We can just jump to the next slide, please. The site's located on the south side of Whitehall Road, between Gregory and McLennan Avenue, just south of Summerhill Avenue. For those a bit less familiar with the area, we're just south of Summerhill Market as well in the North Rosedale neighborhood. So next slide, please. Now this is where the site gets a bit unique. We're actually split zoned. So we're 50-50 in R, and we're also in RD. So as a result of the split zoning, through our zoning applicable law certificate process, Toronto building staff identified our FSI variance twice, and it was actually listed twice. Our FSI variance is for 0.69, whereas 0.6 is permitted, and that's shown on the City of Toronto zoning map here. The property is also located within the North Rosedale Heritage Conservation District, where it is classified as an unrated property. And I'd like to say from the outset that Heritage Planning staff have no objections to the application, and we accept the conditions provided by Heritage Planning staff in their staff report. In the Heritage Planning staff report, Heritage Planning staff also conclude that the application is substantially in accordance with a prior 2015 approval in terms of its massing and front elevation. You go to the next slide, please. This is just some photos of the existing front yard. The bay window that you see on the screen on the existing dwelling today is generally within the same location as the bay window that's proposed through this application. Let's go to the next slide. And these are some photos here of the existing rear yard, first looking north towards the rear of the existing dwelling, and then looking south towards 100 Douglas Drive and 102 Douglas Drive. All of the trees which you see on the screen in the view facing south are proposed to remain, and forestry staff have no objections to our application or conditions. Go to the next slide, please. So this is a bit of a timeline here, and we had to provide a kind of a heartbeat monitor shape or a break in the scale just in the middle because there's a bit of a history to this file. Previously in 2015, while under previous ownership, a similar minor variance application was submitted. It was approved by the Committee of Adjustment, and it went through the TPB, TYCC, and council channels in terms of the demolition of the heritage building on the site today. Under new ownership, our client in 2025, we submitted a new application which originally proposed what I would say a completely different elevation than what you see on red on the left-hand side. Through correspondence with Heritage Planning staff, the NRRA, the Rosedale Residents Association, along with others at the city, we revised our application in November 2025 to propose a front elevation and overall massing configuration which Heritage staff could consider substantially in accordance with the prior approval. And that's our elevation that we have under the blue that's on the right-hand side of the screen. If we go to the next slide, please. So what we did here is just provide a simple summary of all of the variances proposed. We're obviously a 5 variance application, but our driving variances outside of FSI for the larger dwelling are for what I would call 2 targeted or isolated features limited to the ground floor of the building. The first of which is the bay window on the front elevation, the second of which is the breakfast bar at the rear, which is 2 meters deep. Go to the next slide, please. In terms of our arborist report, as I mentioned, forestry staff have no objections or conditions, and no trees are proposed to be removed. Go to the next slide, please. Go to the next slide after this. Thank you. So this is a bit of a study of bay windows along Whitehall Road. Through this study, we found at least 15 other examples of front bay windows for other dwellings on Whitehall, some of which are recently constructed, some of which also include integral garages, which is also proposed with this application. Now, we don't need a variance for that integral garage. Let's go to the next slide, please. So what we've done here, we'll move through this relatively quickly, is we're just comparing the existing rear condition, flipping to the next. So this would be the as of right rear condition, and what you see in red with the semi-opaque box is actually a permitted exception in the RD zone for lots with a frontage greater than 12 meters. This lot has a 12.19 meter lot frontage, and that's a 2 meter deep permitted exception offset 3 meters from each property line. And then flipping to the third slide here, this is our breakfast bar. So this is slightly offset and lower than what would otherwise be permitted in the RD zone as a building length extension beyond 17 meters. Moving on to the next slide. In terms of FSI, for FSI variance, we've pulled a research request of surrounding applications in the area, and we've come to the conclusion that the FSI at 0.69 fits well within the range of the floor space indices approved along Whitehall, Douglas Drive, as well as St. Andrews Gardens. Sorry, Highland Crescent, I should say, closer to Mount Pleasant. So moving on to the next slide. So in conclusion, we've received staff reports from 4 staff divisions, 3 of which have conditions. All of those conditions we accept as part of our application. We have no issues with any of the conditions staff have proposed. And it's my submission to the Committee of Adjustment that there's no undue privacy impacts with the breakfast bar proposed, as none of the trees are proposed to be removed at the rear, and that breakfast bar is just simply slightly offset and actually lower than what would otherwise be permitted. In my opinion, the application meets the 4 tests for minor variance. Thank you.
Thank you very much. I know we've got some folks who want to speak. There's just a couple points of clarification. You received a demolition permit for the previous application.
Yes,
So
that's
does that
correct.
carry through, or did you have to go back and get a new one?
We'll have to go back and get a new one. Heritage staff confirmed with us that this would be a delegated process. If our elevation was not substantially in accordance with that prior elevation which we had shown on that timeline, we would have to go back through the council cycle, the TPB cycle, and the TYCC cycle. But because we're substantially in accordance with, Heritage staff have actually delegated that authority to themselves to issue the demo permit.
One question. At 97 Whitehall, do you know when that house was built? Is it an infill or original home?
I'm actually not sure if it is infill or an original home. It also has, what looks like to be some recent work on that particular dwelling. And it's actually, we do have a slide where we kind of compare our height to their height. We don't have a height variance, but we are of a similar height to 97.
Okay, do you know?
Through you, Mr. Chair, do you want us to hold questions?
I do. I just wanted a clarification
Yeah, yeah.
question first. So if
So-
you've got questions, we'll let the opposition speak, and then
Yep.
we can have at it.
Okay, perfect.
Okay?
Okay, thank
you
you.
very much, sir. All right, do we have our first speaker here or online?
Through you, Mr. Chair, we have 4 other registered speakers. We have 2 in person and 2 online, so we'll start with those that are present here in person.
Who wants to come up first? Don't be shy.
We have a Melanie or Morley registered here. Speaking? Okay. We'll move to the first online speaker,
Okay,
which
so
is
no one
Melanie.
here is speaking to this item? Okay. Yes, Dino?
Mr. Chair, I believe those are the owners of 103 Whitehall, if I'm not mistaken. Is that correct? No, okay, sorry about that. Okay.
Okay, thank you. We'll move to our first speaker then.
Hello, Melanie, you've been unmuted.
Hi there. My name is Melanie Fischler. I live at 100 Douglas Drive, which is directly behind the applicant. And can staff pull up the presentation? There we go. Thank you very much. So good morning, Mr. Chair and panel members, and thank you for hearing my submission. I want to focus the committee on 3 key points today: procedural fairness, tree safety and risks, and privacy and overlook issues. First, procedural fairness. As a member of the North Rosedale Heritage Committee, I've seen the COA process work very well when applicants are open and transparent with their neighbors, and importantly, when they engage fairly with impacted neighbors to understand concerns and take reasonable mitigation steps before coming to your committee. In this case, there's been a failure on both fronts. There's been insufficient notice. The mail strike deprived neighbors of the customary city mailing that provides the notice and application details to impacted neighbors. The applicant amplified this informational deficiency when his agent hand-delivered only a single front elevation and site plan to neighbors, no rear elevation to neighbors like me on Douglas Drive, and a site plan with no windows depicted. And I note the applicant today didn't say anything about the side windows he's introducing, providing overlook to the next door neighbors. The Residents Association asked the applicant to deliver complete plans, and the applicant ignored that advice. Engagement also failed here. Affected neighbors contacted the applicant to outline concerns and propose reasonable mitigation strategies for consideration. Those good faith efforts were ignored or dismissed outright through abrupt emails with no discussion. The result is the diagram you see. Every single impacted adjacent neighbor in the red boxes is objecting to this application and has written a letter of objection outlining their legitimate concerns. And there is not one letter of support. The second issue, if we can flip to the next page, is tree and safety concerns. My written submission outlines the history of the large mature silver maple straddling the rear boundary of my property and the subject property. This is a declining and old tree. If we turn to the next slide, you can see the limb failure that caused significant damage to my property in 2024, and only hours before children were playing on that patio. I note that a number of city trees of similar size and age on surrounding Whitehall, McLennan, and Gregory have recently been removed by the city. Notwithstanding being provided with a number of these images and potential risks, the applicant has casually dismissed every concern raised by me and my arborist, who has a long history with this tree, instead relying on 7-month-old reports designed to facilitate his plans. I just want you to pause and look at the size of those branches. That's 1 year ago. If we turn to the next slide, I've highlighted in yellow the conclusions of my arborist report from November 28th of this year. He highlights the high risk, severe consequences of failure causing injury and property damage. The applicant, who lives in California, may be prepared to casually brush off these serious risks to the property and families of his future neighbors 3,000 miles away. But I submit that having been put on notice of contrary evidence, the city cannot and should not do so without further assessment by city experts. The third issue is overlook and privacy. A loss of this large silver maple, and if you look at their applicant site plans, it provides a huge canopy between the houses, together with an evergreen tree between 99 Whitehall and 97 Whitehall, which they say won't be damaged, but I think there's contrary evidence, as well as the proposed demolition of their applicant's rear garage, will result in the almost fully screened boundary between my home and both 99 and 97 Whitehall becoming fully exposed, where now there's almost complete privacy between the homes. My rear bedroom and bathroom windows will be directly overlooked by both 99 and 97 Whitehall. My suggestion that the applicant consider a joint application for safe removal of the tree and installation of a mature beech hedge screen along the boundary line to mitigate the overlook and privacy issues and replace the lost significant tree canopy was rejected out of hand in a terse email after the application deadline for submissions.
Ma'am, I'm just going to ask you if you could wrap up, please.
Yep. So in conclusion, he's ignored safety, privacy, and overlook concerns that the committee can and routinely does take into account, seemingly on the assumption or advice that the application will be rubber stamped. I'm asking you not to reward that behavior and to either refuse the application or defer it so there can be proper notice and good faith engagement. Thank you very much for your time.
Thank you very much. Panel, any questions of the speaker? See none. Our next speaker, please.
Good morning, Barry. You've been unmuted.
Oh, okay, it's showing as mute. You can hear me now?
Not really, sir. Can you get closer to the microphone, please?
Let me just try turning it up.
Yeah, that's much better. Thank you. Name and address, sir.
Barry Leon, 103 Whitehall Road, so the bungalow that is directly east of the subject property. So, Mr. Chairman, members of the committee, just to pick up on a couple of points that were unanswered earlier, 97 is, which is to the west, is owned by the Melanie and Morley, who you called upon earlier and weren't there, I believe. Secondly, there was a question asked which the agent was unable to answer. 97 is the original construction with an addition on top of it. But turning to the concerns that we have at 103, and I should say that I support the concerns that Melanie Schisler has just outlined, particularly because our concerns are the same in nature, which are loss of privacy and essentially it comes down to loss of privacy. So in our case, there's two ways that loss of privacy will affect us. One, there is, if you look at the drawings on the east side, which haven't been shown, there's a large window which will face our dining room and kitchen. And there doesn't seem to be any need for it. The other windows on that side are below grade, so those aren't problematic, but it's really that one large window that is problematic. There it is. I'm not sure what the purpose of it is because there isn't a lot of light on that side in any event because of the two buildings are fairly close to each other. The upper window isn't problematic, and if you look to the east of 103, there is a house that was built maybe 20 years ago, and it has a number of those smaller windows at a higher level, and that hasn't been problematic. So it's that large window is problematic. I should say also, the front of the house, which the agent addressed, isn't problematic from our perspective when it comes to the window that's there. That's not going to affect privacy for anybody. Then the other privacy concern is the one that Melanie Schisler mentioned, and that's it's had a few different names. Breakfast bar is the name that was used today, but it's an addition, largely appears to be glass, that faces our property, our backyard, and faces Melanie's property. Again, it's an intrusion into the privacy of the neighbors and doesn't appear necessary. It may be a nice to have from the owner's perspective, but the trade-off that they're asking is a significant loss of privacy. The other effect of that breakfast bar or the addition at the back is that it's going to extend well into the 99 backyard, and in turn that will affect the afternoon light and as well as privacy in our backyard at 103. So that appears to be problematic from the perspective of both Melanie and us. And again, accommodation should be able to be made to make it less of what's the word I'm looking for, but open to reduce the privacy on our side, and those would be the main two concerns on the privacy side. And the second part of it, the reduction of light from that same building. Those are the concerns that if the application is going to proceed or if it's going to be deferred, we would welcome the opportunity to have good faith discussions with the owners or the owner's agent to mitigate the problems that Melanie has raised and the problems that I just outlined. Thank you, sir. Thank you,
Okay,
members.
thank you very much, sir. We'll put those questions to the agent when he returns. So were you there in 2015 when this application was originally proposed?
Yes.
And did you have concerns back then?
We did, although what I can't recall is whether the prior proposal included either that breakfast bar or the window. I mean, obviously, having a large construction project next door isn't anybody's idea of a good time, but comes with progress, and we accept that. But I can't recall whether those were those privacy issues existed, and I'm assuming that some of the problems that Melanie identified wouldn't have existed then for her or for the owner then because of the tree issues. Obviously, were different 10 years ago.
Okay, thank you, sir. Oh, got a couple questions for you, Dino.
Thank you, Mr. Chair. Mr. Leon, so I've read all of the 8 letters in opposition that were filed in regard to this application, and specifically, I'm referring to your letter as dated December the 2nd, 2025. I had a couple of questions on your oral deputation and reflected in that letter. It seems that the thread throughout all of the 8 letters in opposition seems similar, and that is procedural fairness, the tree canopy issue, and also the privacy overlook issue. But specifically, you note in your letter a lack of information and due process. And I wanted to ask the Madam Deputy Secretary Treasurer, was notice provided appropriately for this application?
Through you, Mr. Chair, that's correct. Yes, it was.
Thank you. Mr. Leon, you indicate in your letter that you would like this application to be deferred if it's not refused, and based on the fact that you did not receive proper notice in time to consider the proposed plans. I do note that you also go on to say that you expect the applicant to engage in good faith discussions with the affected neighbors. I'll just point out that there's no requirement for the applicant to consult. However, clearly there's an encouragement to do so in order to create, not to create animosity between neighbors and that. But where do you stand on that? Is your position that you would, if this application is not refused, you're requesting a deferral?
Well, I think the same was reflected, at least in Melanie's letter, that the neighbors aren't opposed to the owners improving the property. The opposition comes from the adverse effects that it's going to have on the neighboring properties that I outlined and that Melanie outlined and that are outlined in other letters. So the reasonable solution seems to be, in one way or another, for the owners to sit down with a recognition that these issues need to be dealt with. And Melanie outlined the tree suggestion that was proposed. Likewise, from the 103 perspective, it seems that accommodations could be made both to the large window and the breakfast bar, which is going to affect us and going to affect the neighbors behind. So, ideally, we would come to a resolution that deals with our concerns and allows them to go ahead and build, improve that property and build their home.
Yes, thank you. Are you aware that the architect in a letter submitted to this committee has indicated that they did have conversations and consult with the neighbors?
I did, and the problem is that those consultations didn't lead to an engagement on the issues of the outstanding issues of serious concern to us.
Okay. And in your letter on page 2, or 3, sorry, under general intent and purpose of the zoning bylaw, you indicate, or you state that the RD zone is intended to maintain low-density detached housing and open space around dwellings, and you indicate that the proposal doubles the FSI. What are you basing that on? Because the FSI maximum is 0.6 times the area of the lot, not 0.35, which you've indicated in your letter.
All I can say is that would be an error based on the information that was made available today.
Well, if you look at the public notice and variance number 4, variance number 4 says the maximum permitted floor space index in the residential zone is 0.6 times the area of the lot. The new dwelling will have a floor space index equal to 0.69 times.
I see that, yes.
Yeah.
Okay.
And then just finally, at the end of your letter, you refer to Nova Chemicals Corp. Versus Dow Chemical Canada in respect to divisional court and what they found regarding providing the Committee of Adjustment, providing reasons that adequately explain the rationale for its decisions. There's also, prior to that, Loeb, which is a counter to that decision, to the Nova decision. But in the end, in Loeb, the divisional court found that an oral explanation from the committee in terms of their rationale is sufficient to explain their decision. Are you expecting more from this committee other than going into committee today to discuss our position on this application and then there'll be a decision issued?
No more, no more than
Okay,
the
great.
requirement as the committee understands it.
Okay.
Thank you.
Do you know, maybe we can draw that line to a conclusion, Phil?
Are you the Barry Leon that at one time was employed at Pearlie Robertson, Hill and McDougall?
I was, yes, 2009 to 2000.
I missed this in my review of the materials, but I worked with Mr. Leon. It was over a decade ago, but I'd like to recuse myself.
Okay, thanks, Phil. You can probably.
I've got no recollection of that, but
I was an
Thank you.
Article student at the time.
Well, one of you left a memorable impression and the other one didn't. All right, can we have the agent back then, please?
Thank you, Mr. Chair. So before I begin my responses, and I'll keep these as targeted, as brief as I can, because I do believe the issues overlap amongst the various deputants we heard from today. I'd like to say that our client, myself, and the architect together, mostly through the architect and my clients, the Scrow family, Jenny and Tyler Scrow, have engaged with all of the neighbors that were indicated on the map, which was submitted under one of the other deputants' written materials. We engaged with all those neighbors throughout the month of November through email correspondence. We attempted to arrange telephone meetings and virtual Zoom meetings with some of the neighbors. I won't go into too much detail on that, as one individual decided not to attend a meeting, which we had attempted to facilitate. However, we had met with all of these neighbors throughout the month of November prior to this hearing today. The meetings with those neighbors resulted in the objection letters. We've met with the neighbors, we've received objection letters, we've heard today what their concerns are. Their concerns are similar to the concerns we had in our meetings with those neighbors. And in addition to that, some of the neighbors previously had concerns with height, but when it was determined that our height is less than the as of right height and similar in height to 97 Whitehall, the height issues conveniently dropped off the issues list of some of the neighbors. The next issue is the tree. The tree at the rear is a boundary tree with 100 Douglas Drive. That is a tree which our arborist, the City of Toronto arborist who reviewed our application, and a City of Toronto arborist who 100 Douglas Drive acknowledged through their written submission, attended the site in 2024. So that's a count of 3 arborists have determined does not need to come down. One arborist, retained by the neighbor at 100 Douglas Drive, submitted an arborist report dated November 28th through their written submission, it's the written submission of 100 Douglas Drive, identifying that the tree is of a high risk and may need to come down, but nowhere does the arborist report directly state that it needs to come down as a direct result of the proposal. The arborist report does acknowledge that the construction perhaps could further injure the root base and root system of that tree. That's the one at the back, tree number 4. But nowhere does it directly state that as a direct analytical result of our proposal, that that tree at the rear needs to be removed. Our arborist, of course, proposes that it needs to be retained. On page 10 of 100 Douglas Drive's written submission, their own arborist acknowledges that providing the required hoarding and tree protection zone that the City of Toronto's own forestry division requires would be an appropriate mitigation measure. I believe, I might have my page number wrong, but I believe that is on page 10 of the arborist report written by the arborist, which 100 Douglas Drive retained as an objection to this application. I think the last issue I'd like to touch on is the issue of privacy. First, I'll touch on the issue of the east and west side windows. The proposed dwelling does have side windows on the east and west elevations. I acknowledge that there was an earlier version of the elevation drawings that was submitted that had dropped off some of these windows which you see on the screen. Once we realized that through correspondence with some of the neighbors, we resubmitted for everyone's availability on the record, on the AIC, the plans that everyone is looking at on the screen, the plans that everyone obviously reviewed in advance of this hearing. The side windows that you see here would be facing 103 Whitehall. That's for a stair, that's a large window. Those are side windows which are on the permitted building length. So we actually are not seeking a variance for those windows, nor are those windows part of elements of the massing which require variance, which would be the breakfast bar at the rear, and then that narrow strip of the bay windows that you see on the front. And if we flip to the other elevations, this would be our west elevations, the one closer to Mount Pleasant. So these would be the windows facing 97 Whitehall. Again, outside of the bay window and the breakfast bar, none of the windows that you see in the middle of the screen here fundamentally are part of any of the required building length or depth variances. And in fact, those two windows on the first floor are what we typically call clear story windows. We sometimes call the taller than a person height windows because they're 7 or 8 feet tall. And that's a direct targeted measure for privacy as a good faith measure to our neighbors at 97. Planning staff also have a condition to secure our drawings to the elevations and I believe to the site plan. And I think that that condition is a very fair condition for an application like this where privacy has come up as an issue from some of the objectors. And the last issue, it seems like, is privacy of the breakfast bar feature in particular at the rear. And again, what I'd like to highlight through our presentation, maybe not in the time I have left, I'll try to speak very briefly on this because we looked at this, is that's a slightly offset feature that is actually lower than the 5 meters permitted for that same feature under the RD, residential detached exception, the exception that's in the RD zone. And that's something that we compared the differences of through our presentation. Thank you. I think that's all I need to respond to. And
Great.
staff have responded to the notice.
Thank you, sir. A couple points. Just going back to the elevation, the earlier elevation. So I think I wanted to make sure folks heard. So that large window there, that is a staircase.
That is a staircase.
So that's not going to involve people lingering and looking out, I don't imagine.
It may not. It's a passive.
Yeah.
Typically we don't sit and sip a coffee on a staircase the same way we might in a living room or kitchen.
Well, I don't.
Okay.
And secondly, you've seen the advisory report from Urban Forestry, and in it, it does speak to that boundary tree. And basically, it seems to be not making a condition, but asking for additional details on exactly how you're going to do the excavation and how that's going to potentially affect the tree protection zones. That, you've seen that, and that's your intent.
Yes. Yeah. So I think we have it on the screen here. So we've seen this. We've reviewed it with the owner and with the architect, and actually with the builder as well. And we understand that obviously it's at discretion of urban forestry staff whether or not they issue this permit. So if they're missing information on the sensitive root excavation construction techniques, I think what our arborist is proposing in our report is for arborist supervision during excavation of the foundation and during removal of the footprint of that existing garage. But if that's not maybe satisfactory, through that tree injury permit application, we'd provide forestry staff with any requisite information.
Great, thanks. Any, Dino?
Thank you, Mr. Chair. Can you explain what the classification is of this property within the North Rosedale Heritage Conservation Plan District?
Sure. So the property is classified as an unrated building. Unrated buildings are buildings which don't have significant national, provincial, architectural significance. They're usually not designed by a prominent architect. So this is a property which is classified as an unrated building. and there's no direct, I want to almost say requirement that unrated buildings cannot be demolished. There's some buildings in other heritage conservation districts that, one, or even individually designated that one cannot demolish. But for an unrated building, there's no express requirement that they're not required to be demolished.
All right, and integral garages are strongly discouraged in the plan. Can you speak to that?
Yes. So the integral garage is something which we're not seeking a variance for today under the Foretest of the Planning Act. We're not actually seeking a variance for that integral garage. It is something that's discouraged. Heritage planning staff, through their submission as the experts reviewing our application, actually the city's own experts, have determined that there are no issues with this front elevation. And the previously approved front elevation also had a similar integral garage condition.
Thank you.
Okay, thank you. Anyone else? See none. Thank you very much.
Thank you.
All right, let's go into committee. Anyone want to start us off? Okay, I'll begin then. I look at the original approval of this application back in 2015, and if you look at sort of the elevations anyways, it doesn't appear to me that there is a dramatic difference in the proposal that was approved many years ago. I mean, we didn't really get into why it wasn't pursued, but in terms of the nature of the development relative to what was previously approved, I don't see a substantial or demonstrable difference. I also think that this application is not at all inconsistent with the type of nature of development in this neighborhood. I was struck by the architectural design from a facade perspective that it is very much in keeping, and we don't always get those kinds of developments in these neighborhoods. We sometimes get, ultra-modern applications, which people have different views of whether they're attractive or not. So I also look at the variances before us, obviously, and to my eye, the variances really are relatively minor. The only one that caught my attention initially was the length, and I think the length is restricted to the breakfast area, so it's not I don't think it's a substantial impact on the neighboring homes. And again, a 19-meter length, in my view, is not inconsistent with the large homes and large lots in this neighborhood. So from my perspective, I don't see it as being a significant impact. I appreciate the neighbors' concerns, and I understand some of the issues about privacy, but I think the agent did a good job of going around and speaking to the issues of overlook and privacy. There is no balcony off the rear, so that's a bonus. So from my perspective, I think it's a supportable application. Dino?
Thank you, Mr. Chair. I agree with you in your comments. I would say that massing and height of the proposal provides consistency with the types of architectural expression and heights in the area, and similar in height to most of the neighbors. The building materials and the color also reflect those found in the NRHCD plan, specifically the St. Andrews College lands, and the primary elevation is consistent with other buildings in that area. So I would support approval of this, given the fact that I find that the variances, individual and collective and cumulatively, meet the four tests in the Planning Act. So I would support that, subject to, of course, some conditions.
Yep. Thanks. So just check with everyone else. Anyone has any comments, or you want to move that motion, Dino?
Well, I'll wait.
No, everyone's done.
All right, I will move that, subject to a couple of conditions. The first being that the proposal be constructed substantially in accordance with.
This is the planning condition, right?
Yeah. Also, the transportation review condition with the driveway reconstruction. Although I would suggest that that driveway use criminal pavers. Maybe we could put that as a condition.
We can. There is no front yard landscaping variance requested, so that would be not a condition. That would be something I think we'd ask the agent whether they would be open to that or not. So why don't we just hold there, come out of committee, put that to the agent. The suggestion, sir, is permeable pavers for the driveway.
Is there any possibility, through you, Mr. Chair, that I can confer with my client over text or phone, or if not, I'm maybe pleased to respond without doing so, but just because I wasn't expecting that, as you pointed out, that we don't have the front yard
Right.
landscaping variance, I'm not sure if we can maybe get a hold of the architect in the
Do you
short
know-
amount of
sorry,
time.
Do you know, what's your view on this?
I don't want to complicate this.
Yeah.
You know, it's a suggestion. It would be important if you included it, your client included it. But because there's not a variance for it, we can't include
can't
a
impose it.
condition right now.
So
Yeah.
maybe what we do, why don't we let the agent take that back as a suggestion?
Yep.
But just continue on with the
Sure.
motion.
Yep.
You've got the conditions, there's heritage conditions as well.
I thought that was dealt with already.
I have it listed that they best have to submit their plans and get sign off from
Yeah.
Heritage.
Yeah.
Which
Okay.
is, I'm sure they'll get.
Yeah,
approved.
absolutely. So those three conditions.
Okay?
Yeah.
And there is a forestry advisory, but it's only advisory, and they've acknowledged that they've read that. Okay, motion by Mr. Lombardi to approve with those conditions, seconded by Mr. Bissonnette. All in favor? You have your approval, sir. And take the suggestion on permeable pavers back to your client. Thank you. Okay? All right. Move on to, we can get Phil back in. Are you going to get Phil? Yeah. Okay, we move on to item number 2, 128 Chisholm Avenue. This is an application to alter the existing one-story detached dwelling by constructing a complete second-story addition, a rear two-story addition with an integral garage in the ground level and a new driveway abutting Doncaster Avenue, and two rear second-story Juliet balconies. The existing rear attached garage will be demolished. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 2 photographs of trees on the subject property, covering letter from the agent, and previous decision number affecting the subject property. We have correspondence from Urban Forestry. The agent online.
Through you, Mr. Chair, we do have the agent online to speak. Good morning, Helen. You've been unmuted.
Good morning, ma'am. Helen, you there?
House and adding second floor.
Sorry, ma'am.
Existing
Hold-
bungalow.
Hold on a sec. We missed the first part of what you were saying. If you could just give us your name and address for the record, please?
Oh, sorry. My name is Helen He. Address 160 East Beaver Creek Road, Unit 24, Richmond Hill, Ontario. Representing the owner of 128 Chisholm Avenue. The application is regarding the combined existing, demolish existing one-car garage combined with the main house and adding the second floor to the existing bungalow and new second floor over the garage. This is the second attempt. During the previous hearing, we were told the addition was too much to the neighborhood and leave a limited room to the rear and south yard landscaping. So we discussed with the property owner and make a follow improvement this time. We shrink the 2-car garage to 1-car garage, and the second floor addition over the garage has been reduced as well to flush with the garage wall below. The floor index in this case has been reduced from 0.92 to 0.78, and the lot coverage has also been cut down from 55% to 49%. So the rear yard soft landscaping has been increased from 32% to 58.6%, which meets the requirement of zoning bylaw, 50%. The new two-story addition will have a 1.2 meter setback. Can you pull out the site plan, please?
Okay, there it is.
Okay, so the new addition from west side, you can see we have 1.2 meter setback from the property line. So addressed the concern from the north neighbor. And also we add 6 trees at northwest corner together with privacy screen over second floor window facing the west. So can you pull out the elevation, west elevation, please?
The elevation?
Yeah, west elevation.
West elevation?
Yes. So see, we previously we have a concern from the west neighbor regarding the privacy. So we add like a roof screen. It's not a balcony. It's just a screen over the window to address their concern. So overall, this improvement address all the concern with neighbors and reduce the size of the building and also have enough soft landscaping, which we raised the concern from the previous meeting, and also is less impact to the neighborhood.
All right, ma'am, thank you very much. Panel, any questions? Dino?
One quick question. Ms. E., in your letter to the committee dated October 30th, 2025, at the end you say, as the latest zoning review comments contains irrelevant items to the application, we will prefer using a zoning waiver to proceed. What do you mean by irrelevant items to the application?
Irrelevant is let me see. Yes, it's we don't want to put that item to the committed adjustment. So this is not relevant to this CLP application. I think it's just overhanging.
Okay. All right.
So yes, it shouldn't be included in
Yeah.
there's it's not relevant to this application. So
We took out
Just,
extraneous material that's not relevant to the application.
yeah.
Okay, anyone else? All right, thank you, ma'am. Let's take this into committee. Looks like a substantially improved from the previous one.
So I was on the Committee of Adjustment, Mr. Chair. It was in the summer. I remember this particular subject property, and I look at what I see to be several improvements, reducing the impact to the neighborhood. I think this was done in good faith, and I appreciate the improved application, and I find it supportable.
Okay, do you want to move a motion? Oh, sorry, Dino?
I've looked at this, and in my opinion, I believe that this is overdevelopment of the site. I note that the previous Committee of Adjustment refused both a lot coverage of 55%. The reduction is not that great in the new application. Also, the building length is the same. That was also refused at the committee. I think the lot coverage coupled with the variance for FSI doesn't satisfy the 4 tests, so I'll be voting to refuse the application.
Okay. Phil?
I actually have some trouble with this. Looking at variances 1 and variances in variance 4, so that's lot coverage and depth. And it's because when, you know, we look at variances in terms of the 4 tests, we're looking at the impact, whether the impact is minor. I think those same variances, perhaps with a different design, might be desirable for the development of the land and might be more minimally impacting, but I see these variances as enabling basically the entire side of this home, the way it addresses the street, to just be a driveway into a garage. And I don't think that that's what the zoning is supposed to be. I'm a little surprised that there isn't a rear yard landscaping variance as a result, but I find that effect is not minimally impacting, and I can tie it to those variances. So for those reasons, I won't support.
Okay, I'll just weigh in. I would, in some cases, agree with you and Dino if it wasn't a corner lot. And that's the distinction that I make, that well, 2 distinctions. One, it's a corner lot, so you've got a significant amount of green space and separation of the side exposure to whatever street it is. So I don't see it as being as difficult if it were mid-lock, and notwithstanding the driveway point you make. But given that they've improved it to the point where there is no rear yard landscaping variance, and they've satisfied the bylaw there, and you know, the side yard of a corner lot gives the illusion and impression both from the street and to the neighbors that it isn't as overdeveloped as it might appear given the coverage of the lot. Maybe the lot is particularly narrow, but again, if you include that boulevard, I don't see, I look at it as the impact on the neighbors in the neighborhood. And in this instance, there looks like there was a significant opposition in the first go-round. That opposition has been satisfied in this round. So that's what we want applicants to do, right? Is when we turn something down because the neighbors are ticked, you go back and you have discussions and you satisfy those concerns with the neighbors. And in this case, I think they've done that. So from my perspective, I think it is now a supportable application for those reasons.
So
Katie, do you have any thoughts?
Sure, thank you, Mr. Chair. Thanks for everyone's comments so far. I tend to agree that, given the context of the corner lot, the wide boulevard, as well as the improvements from the previous application, that I'll be supporting this one.
Okay.
Yep.
So maybe Phil, can I call on you to move a motion?
You mean
No,
Ryan? I don't.
Oh, sorry, I said.
Excuse me, can I have a few words? Excuse me.
I'm sorry, no, man, your time is done.
So, I don't see any conditions. Is there? Urban forestry.
Forestry, yes.
Sorry, I just want to look at that.
Okay, condition 1.
So I will make a motion to approve the variances subject to forestry condition 1.
Okay, motion by Mr. Bissonnette to approve, seconded by Ms. Plaitzer. All in favor? Opposed? That motion carries. The application is approved. Thank you all. Move on to item number 3. 763 Lansdowne Avenue. This is an application to alter the existing 2-story detached dwelling by constructing a 3rd-story addition with a rear deck, a rear 1-story addition, a front 2nd-story deck. Also to construct a new 2-story ancillary building, a detached garage with a workshop and storage space above in the rear yard abutting the laneway. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, covering letter from the agent, and presentation materials from the agent. We have email correspondence from Transportation Review and from Metrolinx. We have 6 form letters in support from owners occupants of Lansdowne Avenue, Golden Avenue, Hallam Street, Shanley Street, and St. Clarence.
Mr. Chair? Can I just note that there is an error. This is a semi-detached, not a 2-story detached dwelling, which is described in the purpose of the application.
All right, duly noted. We'll confirm that with the agent.
Thank
you. All right, do we have the agent with us?
Through you, Mr. Chair, we do have the agent online to speak, and there are no other registered speakers for this item.
Good morning. Good morning.
Good morning, all.
Name and address, please, sir.
My name is David Footman, 119 Front Street, Colborne, Ontario.
And sir, you heard one of the members make the point that this is a semi-detached, not a detached, as written in the project description?
I don't know if it's yes, it's the city's project description. It's an error.
Okay, it's an error. So we'll just amend that description to say
Yes,
a semi-detached dwelling.
yes.
Okay, sir, we don't have anyone listed to speak, but I wouldn't mind just a very, very quick overview of your application, please.
Okay, I'll keep it brief. It's a minor variance for the renovation and addition to an existing two-story house and the construction of a garage with a second-floor sewing workshop. I would like to address the house addition first. The proposal has two parts, the rear one-story addition and the third-floor addition. The rear one-story addition is identical to the adjacent property and does not exceed allowable depth. It has zero setback to the side property line, as does the existing semi-detached structure. The lot is short, which requires a minor variance for landscape open space, 35% as opposed to the required 50%. The existing building is very close to the front lot line, and the variances for the front yard setback are already there. The front second floor deck variance is also triggered by the existing building's proximity to the front lot line. Now, regarding the rear garage proposal, the footprint matches the adjacent property garage. The building has a second floor, which requires a minor variance to the height of 1.49 meters extra, and a total floor variance, total floor area variance. The form of this building is identical to two other buildings in the laneway approximately 60 meters north, shown on D photo. The building is consistent with the varied fabric of this neighborhood. There's a 6-story residential building being built directly across the street, which has balconies encroaching onto the front yard setback. This building dwarfs our proposal. In conclusion, we have 6 support letters from the neighbors. We have no planning department concerns. Metrolinx and Transportation Department have no concerns. I believe it passes the 4 tests of the Planning Act. It is minor and appropriate development. It conforms to the intent and the purpose of both the zoning and the official plan. I conclude my presentation and thank you for your time.
Thank you, sir. Panel, any questions? Bill?
The photos you took in the lane, is that in the same block of the laneway?
Yes.
Okay.
And one question, just verifying then that the second story will not be habitable space, correct?
It will be used as a studio workspace for sewing.
Okay.
Okay, so the rear yard landscaping, you're a little light back there, so
Yes.
is there any way that that can be improved?
Not unless we stipulated a green roof or something like that. There's no, if that's something that you require for, that would be fine, but no, I don't think we can change that.
Okay. Any other questions? And you're proposing a 2-story garage, and it's gonna have a workshop and storage on the second floor.
Yes.
Okay. All right, any other questions? See none? Let's take some committee. Go.
The rear addition is obviously minor, and I'm not sure that much in the way of the variances go towards it. Maybe the soft landscaping, but so it becomes a question of the ancillary building, a 2-story. It's taller than these are typically meant to be permitted, unless of course it's a laneway house, and the exception there is to get more housing. On the other hand, I am convinced, looking at this particular laneway, that it is a tight one with other similar structures. It's a home facing a major street. And, I think I view the variances to have the larger ancillary building as minor in the circumstance.
Okay, thank you. Dino?
Thank you, Mr. Chair. I would have to disagree with my colleague. I think this is a bit too much for the property itself. I think the variances, the number of variances, and the variances themselves individually and cumulatively are a bit too not minor, in my opinion. Specifically, variances 1, 4, 7, 8, and 9. You're looking at, for example, variance number 9, it's almost twice the permitted total floor area. Also, variance number 1, which is FSI, is almost at 1.1, sorry, 1.0. And I think I have a concern with the rear yard soft landscaping variance itself, so I won't be supporting this.
Okay, thank you. Anyone else? I'm sort of in between both of you. I agree with Phil that the main building, I don't have any, frankly, I don't have any major concerns. I think that the proposal is pretty consistent with what we're seeing on Lansdowne in terms of additions. They are tight lots, so I don't have any problem with that. I do have an issue with the laneway, with the ancillary building. Some members have heard me on this item before, but I do think that, granting relief for height should be offset by a community benefit. And to me, the community benefit is additional housing or accommodation. So that's why we are into laneway suites and garden suites, is that additional height represents a public good or a public benefit. And in this case, adding storage and a workshop, yeah, isn't, to my view, isn't a benefit to the broader community. So I would also note that the height is a flat roof as opposed to a peaked roof. So I think the impact, notwithstanding the fact that there are grandfathered buildings like that on the laneway, who knows what their use is, maybe they are also laneway suites, I don't know. But in this instance, I can support the main building, but I can't support the ancillary building. So that leaves us with a little bit of a conundrum. We have different views. So maybe I can ask someone, if anyone else have anything to say? Maybe I can ask someone to take the crack at a motion. Phil?
Sure, I'll move to approve it, and we'll see where it lands.
Okay. There's
Sorry, as amended.
As amended.
Any conditions?
I see no conditions
Okay.
requested.
Motion by Mr. Gauche to approve, no conditions. Do I have a seconder? Seconded by Mr. Bissonnette. All in favor? Opposed? Okay, that motion fails. So I'll need another motion. Dino, did you want to take a crack at yours? No. Then I'm gonna have to look for you. Katie, are you okay? What do you want to try at?
Sure.
Are you opposed to it, or are you looking at a hybrid model?
I'm opposed to the second story on the ancillary structure that doesn't offer the public
Okay,
good,
so-
as you've suggested. So I could propose a motion. Are we able to approve everything
Yeah.
Except for particular
Yeah, so what you
variances? Yes.
might want to do is, we'll just say, you're gonna make a motion to approve certain variances and refuse other variances. So if we can go through and determine
Understood.
which ones you like.
Sure. So I'll make a motion to approve variance 1, approve variance 2, 3, as well as 4, but to refuse variance number 5.
5, and you keep going.
Oh, 5
Next page.
and, there we go.
It's
6, 7, 8, 9, and 10.
Correct, okay. Sabrina, you got that? Okay, so motion to approve variances 1 to 4 and refuse variances 5 to 10
As amended.
as amended. Can I get a seconder on that? Bill, seconded by Mr. Gauche. All in favor? That's unanimous. Okay, we have approval of the main building and refusal of the ancillary building. Thank you very much. Well done, guys.
Creative.
Okay, let's move on to item number 4. Number 4 is 422 Clinton. This is an application to construct a new 2-story detached ancillary building containing a laneway suite with a covered entrance. The second story will be cantilevered at the west portion of the building. The existing detached garage in the rear yard will be demolished. There'll be a total of 5 residential dwelling units on this lot, which is currently under construction, as approved by a previous minor variance decision. Committee has before it a copy of the plan of survey, site plan, floor plans, and elevations revised, site plan, floor plans, and elevations received December the 1st, red line public notice, December the 1st, revised zoning notice received December the 1st, 4 photographs of the subject property, a covering letter from the agent, and a previous decision number affecting the subject property. We have email correspondence from community planning and from urban forestry.
Through you, Mr. Chair, we have the agent online to speak, and there are no other registered speakers for this item.
All right.
Good morning, Eddie. You've been unmuted.
Members, my name's Eddie Perez. I'm at 537 Rogers Road.
Great, Eddie. Can you just speak up a little bit, please?
Can you hear me now?
Yeah, that's better. Thank you.
Yeah, okay. I'm Eddie Perez. I'm at 537 Rogers Road. And as per planning's request, we made some minor changes. And
Can
I
you
feel
just,
that how it meets the
Eddie,
fourth test.
sorry for interrupting. Can you just take us through the red line public notice and just confirm what changes you've made, please?
Yeah, we reduced the structure of the building, so the rear became extra landscaping. Originally, we had 23.5, now we have 25.39, because we reduced the length of the proposed laneway suite. And also, by doing so, it changed the variance number 4 went away. The rear yard went from 6.35 to 6.80, so we have more rear yard now.
Sorry, Eddie, I'm sorry for interrupting. Apologies. Okay, I've got it. Never mind. Thank you very much. I've got it.
Yeah.
Keep going.
Yeah, so then the only number that went up was the percentage went from, we had 76, now it's 74.40. That's due to the way they do the calculations, but the green space is actually more than what was before. So that's what's here before you, and we did it as per planning, and planning was okay with all the changes that we made.
Okay. Panel, any questions of the agent? Okay. We'll take this into committee then. We often see these which, when you see a laneway or a garden suite associated with a multiplex, a substantially higher number of variances. This is fairly modest. Yes, Dino?
I agree. The proposal has been improved. Instead of originally 4 variances, 1 variance has been eliminated, and that was due to the recent adoption by City Council in terms of angular plane projections for ancillary buildings, garden suites, etc. I think this is an improvement. It includes a slight reduction, a decrease in terms of soft landscaping between buildings, a slight reduction in setback between buildings, and a slight increase in the laneway suite height. So I'm prepared to move a motion to approve the amended application subject to the urban forestry condition.
All right, motion by Mr. Lombardi to approve, seconded by Mr. Gauche. All in favor? You have your approval. Thank you, sir. Move on to item number 5.
Through you, Mr. Chair, we just need to pause.
Oh, we got
YouTube's
it.
having issues. Okay.
Technical issue?
So can we unmute the room again? Unmute the room. Yeah.
I'm sorry? Oh, so do you want to take a 5 or 10 minute break?
Let's take a 5-minute break, Mr. Chair.
Okay.
Members, please turn off your videos, microphones.
Okay.
We'll mute the room. If everyone can just turn on their microphones.
Remember, it's gonna be a delay,
Microphones on our laptop or here?
There.
Okay.
Testing, testing, 1, 2, 3.
Testing? Testing?
so it's 10 seconds delay.
1, 2, 3, testing?
Testing? Testing?
Testing, testing, 1, 2, 3.
Testing? Testing?
No clicking?
Sound fine to me.
Yeah. Okay.
What it was, it sounded.
Please turn off your microphones.
So maybe that might be.
Yeah, no worries.
15 seconds.
That's more.
It's Ryan. Okay, members, please turn on your videos, microphones. We'll unmute the room.
All right, we resume with item number 5, 125 Howland Ave. This is an application to alter the existing 2.5-story semi-detached dwelling by constructing a front barrier-free access ramp with guardrails connected to the existing front covered porch. The rear deck will be constructed within full compliance with zoning bylaws. We have, committee has before a copy of plan of survey, site plan, floor plans, and elevations, 4 photographs of subject property, covering letter from the agent, an arborist report, and correspondence from the agent. We have staff reports from urban forestry.
Through you, Mr. Chair, we have the agent online to speak, and there are no other registered speakers for this item.
Mr. Chair, can I suggest something? Do we need a presentation?
Oh, I'll get that.
Okay.
Just wait till we introduce the speaker.
Good morning, Lou. You have been unmuted.
Good morning, Chair, members of the committee. My name is,
Yeah, go ahead, sir.
yeah, can you hear me?
Yep.
Okay, yeah, my name is Lou Parente. I'm the agent for this address, and yeah, I think.
Hang on a sec, sir.
Sure.
It's a fairly straightforward application. I don't think we're going to need a presentation today.
I didn't think so.
Members may have some questions. Is there anything you'd like to share with the committee before we go to questions or take it into committee for a decision?
No, just that we're trying to facilitate, you know, the homeowner's daughter who's confined in a wheelchair. So we want to make her life a little bit easier. The rear deck that's mentioned in the in this application, that was approved under a previous building permit. So I think it got into the application because of the arborist report. He accidentally included the deck in the back, but again, that deck was approved and constructed under a previous building permit application, which included interior alterations.
Okay, that's great, sir. Thank you very much. Panel, any
You're welcome.
questions? No, sir, we don't have any questions. It's a fairly straightforward application. We'll take it into committee for decision. Dino?
Yes, thank you, Mr. Chair. I'm prepared to move a motion to approve the application and grant the one variance requested. I don't think there are any conditions.
Okay, motion by Mr. Lombardi to approve, seconded by Ms. Plaitzer. All in favor? You have your approval, sir. Thank you very much. We move on to item number 6, 55 Palmerston Square. This is an application to construct a new 3-story detached dwelling with a front cantilevered 2nd and 3rd stories, as well as front and rear 3rd-story dormers, a covered front porch with stairs, a front basement walkout with stairs, and a rear ground floor deck with stairs. Committee has before it a copy plan of survey, site plan, floor plans, and elevations, revised site plan, floor plans, and elevations received November 28th, red line public notice received December the 1st, 2 photographs of subject property, covering letter from the agent, previous decision numbers affecting the subject property, certificate of official and municipal addressing of properties related to the previous decision, presentation materials from the agent. We have a staff report from urban forestry, support from no name provided, no address provided. We have opposition, correspondence and opposition from 787 Euclid. We have the agent.
Through you, Mr. Chair, we have the agent online to speak, and there are 2 registered speakers.
All right. Thank you. Good morning, sir.
Letters of support that were registered.
Sorry, just a little louder, please, sir.
Sorry, we actually have 3 registered. There's one from 59 Barton,
Oh, is
which
this the agent?
Yes.
Okay.
Oh, sorry, I'm the agent and the owner, Breck McFarlane.
Okay, and you live at 55
15.
Palmerston Square?
I live at 1514 Dundas Street West.
Okay. All right, sir. There's some folks who want to speak to this item, so we'll need a presentation, please.
So,
Just before we go, sir, let's just quickly go through the variances in the public notice so that everyone understands exactly what you're changing. We're pulling them up on the screen now. So you're
That's
changing, you're removing item 3,
That's right, there is no main wall height variance.
okay, and you're removing item number 4?
That's the same, it's the main main wall height variance.
Okay, so those are the only changes you're making today?
Yeah,
All right, then
so.
let's
the
go back and
only-
you can have some time to give a presentation, please.
Okay, so I'm hoping the committee sees this revised proposal as I do. Its form is complementary to its neighbors, and in the drawing there, you can see the neighbor on the right. On the north side of the square, you have 57 and 59 Palmerston Square that are both 3-story mansarded with straight vertical sidewalls. 57 Palmerston Square, the closest one, as I coordinated with the community planning, has an FSR of 1.66 times and 0 rear yard setback. 59 Barton at the top of the lane, parallel to the property, has FSR of 1.725 approved, a building permit for that, and 0 rear yard setback, and is the rear wall of the depth of the 3rd floor and 2nd floor is identical to the one I'm proposing. Okay, so the 2 variants I'm seeking are porch side setbacks and floor space ratio. So the side setbacks I already have in my existing approval, front stairs setback approval. But because I have a landing now, they required it to be approved. So it's not a front porch, it's just a 4-foot wide landing to get into the front door. So virtually every house on a lot under 6 meters wide has its entrance and stairs at the lot line, so porch and entry stairs have to be located there. The existing approval approved the front steps, but zoning considers a revised landing a porch. Regarding floor space ratio, community planning reviewed several examples from my close neighbors where FSR is similar to or higher than mine, often with no rear yard setback, and concluded the main wall height variance was the only concern. 2nd floor separation is actually 12.89 meters, and at 765 Euclid to 25 Palmerston Square, which can be seen at the bottom of the location map, 2nd floor separation is only about 8 meters. The original submittal needed the height variance, because I had misread the zoning bylaw because there was a live map showing a 10-meter height. Besides how simple and rational the plan is, and it's for a family house, I like that the curved roof will change constantly with the light throughout the days and seasons. Let me just go back and read. So this version of the house is a family house, which makes better use of existing infrastructure, promotes active transportation and complete communities, and it'll be more vibrant for the neighborhood than for a house that's suitable for a couple. So basically, that's my proposal. And if you look at on the right here, the 3-story house shaded, those houses, their first 3 houses there are all 3 stories, and they used to be 2 stories. Just like the one south of me that I've shown, you can see that my 3rd floor and its roof level structure are basically identical. So at some point, that's going to have a 3rd floor. Okay, anything anyone wants for clarification?
Okay,
I
sir,
think
thank you very much. Just so for everyone's edification, this was previously the subject of a severance, a front-to-back severance back in '23, right?
Correct.
Yeah. Okay, Dino, anything, we do have speakers, Dino, so is this burning or?
Just a quick question, unless you want me to wait.
If it's a clarification, fine, but if it's a question, maybe we'll wait till after the speakers.
Yeah, it's just a clarification on why the second and third floor are cantilevered. I don't know if you want to.
That's probably better for
Yeah,
later.
okay.
Okay? Let's go to our first speaker.
Good morning, Robin. You've been unmuted.
Good morning.
We'll move on to the next speaker, and I'll try another method
All
to
right.
reach Robin.
Joan McCollum.
Hello, I'm having trouble accessing this particular
Okay,
file.
ma'am, we can barely hear you. If you can either turn your volume up or get closer to your microphone, please.
Just a second till I
That's better.
Is that better?
Yes, that's better. Thank you.
All right.
If we could have your name and address, please, ma'am.
Yes, I'm Joan McCallum, and I live at 791 Euclid. So when my lot runs all the way through the lane, so that the back part of my lot is directly adjoining this particular property. I'm quite concerned about the the size of this building, because the back of this building is going to be quite close to the back of my house. And so the distance between this building and my house will be less than the distance between the other houses on Euclid and the other houses on Palmerston Square. It's going to sort of be right in my face. And I'm also concerned about the overall height of it, because it is going to directly impact the light that comes into my garden. I have an old, well-established garden that's not just a few pots of petunias, which will be directly impacted by this building. And I'm also concerned about the impact that this building is going to have on my probably century-old silver maple tree, which is at the back of my property right on the lane. This is going to, I hope that forestry comes and has a look, but I haven't seen that they have yet. And it would be a shame to lose this tree, which is probably a neighborhood landmark. And so I don't know how to address that. So in effect, although this is considered legally a street front building, technically, practically, it fronts right on the lane. So it's kind of in line with all of the other garages on the lane. So it's a bit of an odd fish. It feels like a house that's really a street front house is actually imposed on a lot that's basically a laneway lot. So I object to its size and its height.
Okay. All right, ma'am. Thank you very much. Panel, any questions of the speaker? See none? Okay. Thank you, ma'am. Let's, can we get the previous speaker?
Hi, Robin. You've been unmuted.
Hello. Thank you. Yeah, I live next
Hold it,
door
sir.
to.
Sir, just for the record, your full name and address, please, ma'am, or sir.
My name is Robin Fulford. I live at 793 Euclid Avenue, right next to Joan, who just spoke. She's at 791. And I know that you have a letter of against the proposal 2 from 787 Euclid. And the three of us are the ones who are impacted most by this proposal. And just like last time, we had problems with the height and the privacy concerns and the light that might be compromised. So, you know, back then, if I remember correctly, the proposal for the 2-story got the go-ahead. or that was the suggestion, I think, and we would much prefer that. We think it's a better fit for both the neighborhood and for our particular concerns. We're the ones who are most closely affected. I would also mention that the 3 letters of support are not from people who are directly affected at all by this particular construction. So they, you know, the fact that it's going from 0.6 times the area maximum permitted to 1.69 times the area of the lot, you know, this is overkill from our point of view, and we would much prefer to go back to that 2-story model that will work for us. Not ideal, but it will work. And also we have concerns like Joan has just mentioned about the big sugar maple or silver maple at the back and how it might be affected by this construction. Thank you.
All right, thank you very much, sir. Panel, any questions of the speaker? None? Thank you very much, sir. That's it, so we'll
Thank you.
have the agent return.
Hello?
Hello.
Hi.
So
Yeah.
you've heard some concerns from your neighbors. I wonder if you could take a moment to try and address those?
Sure. If you look at the location plan, okay, so if you look further down, you can see there's a dark one at 27. That's actually the old garage before the new house. The new house goes only 2 bricks from the house at 25 to the south of it. So it's virtually in line with the house to the south of it. And then if you look at the 2 houses at 23 Palmerston Square and 765 Euclid, that's only about 8.1 meters. And those are both 2 stories houses. So my second floor, as I said, it's 12.89 meters, and at the 3rd floor, even more. Joan and the Robin, they really don't have backward-centric houses anyway. Plus, my 3rd floor, which I pointed out, the 2nd and 3rd floors both align with 59 Barton at the top of the lane. Aligns perfectly with that. And as you see in my 3rd floor, there's no rear-facing windows, so there's no privacy concern. I think with respect to the silver maple, I did submit only this morning in 2022, we had our hearing deferred because the city had missed an element in the zoning bylaw, or the variance. So they had to rewrite it because, and so I had time to do a root excavation study, and it showed only one root of 5 centimeters, and I actually submitted to GOLSA this morning, or last night, a photograph of the roots that were found, as well as the 2022 root excavation report. So I just want to make it clear that up until about 10 years ago, Joan had a garage there. And so the tree was not growing under the garage, the root system, because there wouldn't be any water there. So that's why there was so very, very little root activity at the property line. We dug inside my garage. And then if you go back to my site plan, you can see that's there. 57 Palmerston Square is the first one. Could you zoom out, please? There, 57 Palmerston Square is the first house. It's basically completely on the lane, as you see. And so it doesn't really matter. I look straight out, it's a very beautiful view, and I'm not affecting anyone's privacy, which is why my neighbors here probably didn't come and dissuade or talk against it. So I think with a 13-meter separation at the second floor and even more at the third floor, it's actually about 5 meters more at the third floor, because our second floor tails of our building are about 5 meters past our third floors on the Euclid side. Plus, I pointed out in my letter to the committee, if you pull up my correspondence letter, my cover letter to the committee, I gave you a number of comparisons, but mostly this is, I coordinated it all with community planning, and community planning, who understands the planning regimen and was quite happy with it, and pointed out that their only concern was the height wall variances, and they suggested how I might address it, which I did. And the funny thing is, it's nicer and more elegant than the other version. So, yeah, I mean, that's right. You know, I've done everything I can do. I also think this is if you look at the plans, they're very rational.
Okay, sir, I'm just going to ask you to wrap up, please.
Yeah, with respect to the cantilever, the approved version actually is solid out to the laneway at the north corner and is cantilevered for 4/5 of the lot width. This one is cantilevered the whole way, so at the ground floor it allows my neighbor to the south pure unfettered view north. Whether you're cantilevered or whether you have 4-inch steel posts, or if you have 9-inch round columns, is neither here nor there. It's almost like there's a dislike of cantilevers because they're modern, but it has nothing to do with anything really.
Okay, sir, thank you very much. Dino, does that answer your cantilever question?
I suppose. I have one question.
Yep.
Additional question to the deputant. I have a concern with variance number 5, which is the FSI increase. So you've heard from your neighbors that they have a concern with regard to, and I'll paraphrase, overdevelopment of the site or density. And density refers to the size of the building in relationship to the lot in which it's located. Now, FSI is an indication of density in the OP, and on a site, or on this site, it's a ratio of the total floor space to the lot area. And FSI regulates massing and built form. So how do you justify that almost 3 times of an increase in terms of FSI?
I coordinated that with community planning, and community planning reviewed all of the properties that I had illustrated. If you go back to the location plan, so the first, actually go back again. Okay, so at the top of the lane, there's a darker 59. That's approved at a higher FSR of 1.725 with no rear yard whatsoever. The west of that, number 61, is 1.89 times. The closest one on the north side of the lane, right, is at 57 Palmerston Square, is 1.66 times with 0 rear yard setback. The second, its semi-detached neighbor at 59 Palmerston Square is 1.50 times. So, and then if I want you to look at 767 Euclid, which is the really big one, and notice how close the rear yard is, the rear lot line is to the building. It's like about 3 feet. So you can adjust FSR just by shifting your rear lot line. My rear lot, my backyard is 3.5 meters. The Euclid part is 4 meters because I wanted a balsam fir tree to be fully on the Euclid property. I could have just shifted my backyard line, because I chose it, 0.5 meter, and then I would have been at maybe 1.6 times. The
All
other
right.
thing is,
That answers my question.
Great,
Thank
thank
you.
you. Anyone else have
Thank-
any questions on this one? See none. Okay, let's take it into committee. Anyone want to, Phil?
So this is an odd
Oh,
one.
sorry.
Yeah, no, that's fine.
I didn't see your hand. I saw his, but you want to go ahead?
Go ahead.
Oh, okay. I was just, my thought is, it's a very odd lot. I wasn't part of the severing, but for the lot to be developable, it essentially needs to have these variances. I think it's creating a very modest home. I think there has been some thought into making it less impacting on the neighbors. I think that is part of the rationale of the cantilever that we heard. If you look at the ground floor, it allows a view from the neighbor to the south's window. And FSI doesn't really fuss me that much in a case like this, right? Because minor isn't about a numerical calculation, it's about impact. And the neighborhood, as we heard, has many homes with a higher FSI. But again, on this lot that has been created, to have a unit of a family size, which is what we're hoping to get more into our neighborhoods, especially neighborhoods like this that are surrounded by subways, you need that FSI. So to me, it's quite approvable, and I'll be supporting it.
Okay. Ryan, did you want to add to that?
Yeah, I was just noting how odd of a lot it was and how it's accessed from Palmerston Square. I agree with Phil that increasing density, providing more housing is important. It's city policy, it's provincial policy. I think it's a desirable development and adds much needed living space in an already dense neighborhood that, as Phil mentioned, there's adequate transit. I think it's very supportable and be voting in favor.
Okay, I'll just note, so I was on this one, I recall, and this was I think it was a fairly, it wasn't contentious, but it did garner an awful lot of attention. But I think when the decision was made to approve the severance, it was contemplated that there would in fact be a structure, a building, a dwelling on this site. So I think your point, Phil, is right. It's, given the unique nature of the lot, this is not an unreasonable application. Yes, Dino?
I agree with the comments. I will indicate that this is an older area in Toronto, obviously, where there are tight side yard setbacks, smaller buildings, although 3 stories are now common in the area. In respect to what we heard from those in opposition, there's no variance for building height. The applicant has reduced the number of variances, and I appreciate that. And I will also support this application amended, obviously. And there is a condition that if
All
there is
right,
a
thank
motion
you.
forward.
Who wants to move a motion? Phil, since you started, why don't you do it?
Yeah, sure. Happy to move a motion to approve this as amended, subject to Forestry 2.
Okay, motion by Mr. Ghosh to approve, second by Mr. Bissonnette. All in favor? You have your approval, sir. Thank you very much. Move on to item number 7. 1481 to 1535 Yonge Street, 1 to 31 Heath Street East, 30 to 36 Alvin Avenue, and 22 St. Clair Avenue East. This is an application to alter the development standards for a mixed-use development comprising a 13-story building and 3 towers, connected by a shared podium on the lot by reallocating a portion of the residential density from Building 1 to Tower 1, increasing the building height of Tower 1 from 44 stories to 46 stories, decreasing the height of Building 1 from 13 stories to 4 stories, increasing the height and projections of the mechanical penthouse and architectural crowning elements associated with Tower 1, modifying setbacks and separation distance by relocating Tower 2, and altering the podium element below Tower 3. Phew. Committee has before it a copy plan of survey, site plan, floor plans, and elevations, covering letter from the agent, an arborist report, a parking study, a planning justification letter, presentation materials from the agent, shadow study analysis, the related site-specific zoning bylaws affecting the subject property. We have email correspondence from community planning and from the director of community planning. Mr. Bronskill.
Through you, Mr. Chair, we have 2 registered speakers here for the item, and they're both here in person.
Okay, over to you, sir.
Thank you to staff. Last name's Bronskill, first initial D for David, here as the agent. My address is 333 Bay Street, Suite 3400, and I'm joined at the podium, probably more importantly, by the person who knows this application inside and out, Claire Ricker from Bousfield. So if you do have detailed questions, you may see me, Mr. Chair, defer, but we do have a presentation that we could walk through quickly, although I think there is also the planning staff report that is in front of you, which we're proud of in terms of having their support for these revisions.
So thank you very much. And it is just shifting density from one tower to another.
Yeah.
It is from the purpose of the application, it sounds very complicated, but I think it's fairly understandable. But why don't you just take the very quick overview of it for the panel members?
We can do that. We've got, it's 11 slides. We've got more slides than variances, Mr. Chair. We've got 7 variances, most of which are interrelated, but 11 slides. The good news is the first slide's the cover page. The second slide just shows you the subject site, northeast corner of Yonge and St. Clair. There is an approval on the site today that we worked extensively on, leading to 2022 bylaws. And if we can go to the next slide, if you don't mind. This just shows you the surrounding context, which everyone will know well. Subway station, obviously there, running north on Yonge Street and south into the downtown. Avenue Road over to the west, and the St. Clair dedicated streetcar line coming through. The next slide we just included to show you, zoomed in a little bit, some of the heights either proposed or approved in the area. The 3 tower site you can see for this parcel at the northeast corner as it comes up there to Heath. And just in general there, Mr. Chair, and for the panel, there are similar heights in that area, and even going west over to Avenue Road, there's, I'm going to say, a taller proposal that's come forward at the southeast corner over there at Avenue Road in St. Clair. So heights really in line with what's in the area. One thing I'll just note on that slide for you, we're showing the 49 stories, although it's 46 technically to the top of the residential roof. But the way the building's been designed, that I'll show the panel in a moment, we're treating the 2 mechanicals and in fact the architectural element as 47, 48, and 49. So we put it as 49 on the slide just because that does form part of the height, but we think actually is an improved architectural design. Variance application, those 3 bullet points, I think, Mr. Chair, on the next slide are actually there in the purpose, and so I'll skip through to the revisions. This block diagram, I think, very clearly shows you what's happening. I'm going to start on the left most slide, and in the leftmost portion of that slide, you can see in the faint red line that taller podium element is actually being stripped away. We think that's going to lead to an improvement to both the streetscape on the adjacent streets, but also the lovely pop space, mid-block connections, the public space that's being provided here. That density is reallocated, as you can see, when that nice red arrow up to the top of Tower 1. Tower 2 shifts forward, and then finally on that right-hand slide, you can see that there's additional sculpting, both of the podiums as they are decreased in height, but also of the tower where it has been increased in height. And that's, you can see those 3 levels or stories that takes it from technically a 46-story residential building, but 49 stories with those additional elements. The revised site plans, the next page, you can see again the park, the mid-block connections running east-west through the site. Tower 2 shifted a bit to the north, but still the tower separations remain in compliance with the city's tall building guidelines. Next slide's a busy one, page 8, but this is the one that sort of shows, I think, the most important changes. On the right-hand slide that has the color, you can see the increased height for Tower 1. You can see the location of Tower 2 pushed north. Again, the tower separation distances remain in compliance with the tall building guidelines. And then the green areas show the sculpting of those podiums. So it's not just taking away that additional height, but there is some sculpting of those podiums there. Some of them are slightly closer to the streets. You can see, for example, at the northeast corner, that 20-meter height element is a little bit closer than where the 23-meter height element, but that's all been worked through with city staff just to revise at this plan. And then that public space that you've seen on the previous slide, we think is improved by these lower heights and the different separations. Next slide, through you, Mr. Chair. I was in front of you before when we were talking about mechanical penthouses, and we made sure we were anticipating potential questions of one of your colleagues, Mr. Chair. And so we wanted to have this slide in here to show how part of that first story of mechanical is mechanical and amenity. We've then got mechanical on top of it as we taper. That's why there's some additional height beyond what you would typically see for the mechanical penthouse. And then the final element on the next page, variance 3, is actually an architectural crown. And I'm using that term deliberately from the architects, an architectural crown. It ends up concealing the mechanical penthouse. So this is a really well-designed top to this building, important to the client, important to the architects. That generates that additional projection above the mechanical penthouse. That's the application in a nutshell, Mr. Chair, through those slides. Fortunately, the last slide, 11, is just a thank you and an invitation for question and comments.
Great, thank you very much, sir. Any questions? Phil, I think he was referring to you.
I do remember this, and
I do.
And I'm glad you do as well. And in fact, if that proposal had been architecturally crowned, I probably wouldn't have asked the question. So thank you for raising it here. It makes a lot of sense. Looks great.
Okay. Thank you. I don't imagine we have any other questions. Thanks for the presentation. Thank you for coming down. Let's go into committee. Bill, or Dino?
Thank you, Mr. Chair. I think this is a smart reallocation of the density within the development site, and I think it also attempts to address the building heights, step backs, according to the existing built context. I also think that the proposed revisions are generally in keeping with the plan that the site was established in 2022. So I'm prepared to move a motion. I'll wait for my colleagues if they have any.
Oh, I think you should just go ahead. I
Okay.
don't think anyone's going to refute you. Just, are there conditions on this?
Yes, there are two.
Okay, go
Yeah.
ahead.
So I'll move a motion that we approve the application and the variance is requested, subject to conditions from TTC 1, 3, and 5, and I believe there's also a condition from Urban Forestry for privately owned and publicly owned trees.
Okay. Motion by Mr. Lombardi to approve those conditions, seconded by Mr. Bissonnette. All in favor? I have your approval. Thank you very much. And you.
Yep.
You as well.
Okay, item number 8. HOLMESDALE Crescent. This is an application to construct a new rear 2-story ancillary building containing 1-car garage and 1 garden suite with a second-level concrete deck. There will be a total of 2 residential dwelling units on this lot. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, covering letter from the agent, previous decision number affecting the subject property, and a tree protection plan. There is email correspondence from Heritage Planning and staff reports from two staff reports from Urban Forestry.
Through you, Mr. Chair, we have the agent online to speak, and there are no other registered speakers for this item.
Okay.
Good morning, Marco.
Chair.
You have been unmuted.
Good morning, Mr. Chair, members of the committee. My name is Marco Vieira. I'm the agent and the designer for this application, and my address is 257 Dunraven Drive.
Okay, sir, just hang on a sec. Panel, does anyone either want or need a presentation on this one?
No.
Want to go to questions?
Yeah.
Okay. Sir, we've read your application. We're familiar with the material. We don't need a presentation today, but we may have questions. Is there anything you'd like to share with the committee before we do that?
Through you, Mr. Chair, I'd just like to clarify a simple thing that I believe is just a typo. On the purpose of the application, there's a brief description of the existing. So the existing dwelling is a triplex already. So there will be 4 units on the lot if this proposal is approved.
All right.
It doesn't affect the variances, doesn't change anything or in our proposal, but for clarification purposes, if that needs to be amended.
Okay, and that's, you were here previously to get approval for that?
No,
Triplex?
this was done years back, and I had no connection to
Oh, yeah,
that
it
previous
goes way back,
application.
yeah. Okay, gotcha. All right, thanks, we'll make that change. Dino?
Just a quick question of the deputant, Mr. Vieira. If I could have on the screen one of the elevation drawings, the side elevation drawings. It appears to me that does the property slope up as you go towards the rear of the property?
Through you, Mr. Chair, yes, it does. It has a significant change in elevation from about currently is about the mid position of where we're proposing to put the garden suite.
Right.
And then it goes up to the rear, and then there's an existing retaining wall, and it further extends up towards the property to the north of us.
So technically then, is the second floor, a concrete deck, is that actually at grade there in the rear?
It's approximately 1.2 meters above the grade in the rear.
Right.
So it does read as a second story balcony, and it appears as such from the front, but from the back half and about halfway through the side elevations, it's a 1-story protrusion, let's call it, at the rear of the garden suite.
All right, thank you.
Okay, thank you. Anyone else? No other questions. Thank you very much. We'll take this into committee. Phil?
Yeah, so it's a large garden suite. The photos also show the grading at the back. It's a large lot, it's a unique lot, it's uniquely graded. And in the context of that, all of the variances sought sort of fall into place. And when you look at the plans and you look at the photos and consider the lot, to me it is an application that meets the 4 tests as minimally impacting and appropriate. Under the OPA to add the unit here. I'm
Why
seeing
don't you-
nods from my colleagues, so
Why
maybe
don't
I'll
you go ahead?
turn it into a motion here to approve, subject to forestry conditions 1 and 3.
Is it RNFP or is it forestry or is it the same thing?
It's, through you, Mr. Chair, it's urban forestry number 3, and
Yeah,
then
yeah.
ravine number
RFNP
1.
was number 1. Yeah, sorry.
And then it's as amended.
Similar.
And Mr. Chair, a friendly amendment to that, an additional, additional condition, the driveway being constructed with permeable pavers. I know it's not, a condition that
Are they,
always
Are
include.
they light on rear landscaping?
Yes.
Yeah, I would tend to include that only if there was landscaping variance, but
Yeah.
I don't.
Yep.
I don't see one, so I'm hesitant to add it because I don't really view it as related to the application as much as I agree that it would be an improvement. I just am uncomfortable to add it.
Fair enough.
Yeah, just in future, we can always, when there's no variance, we can always ask the applicant if they're
Yeah.
willing to do that, and if they agree, that's great. If they don't, then we can't penalize them for that. Okay, motion by Mr. Ghosh to approve with the 2 forestry conditions, seconded by Mr. Lombardi. All in favor? You have your approval. Thank
But
you very
perhaps a message to the applicant that, we would love if they constructed that with permeable pavers. It's not a condition, but no reason not to do better.
Okay, we move on to item number 9. 1337 to 1355 King Street West. This is an application to alter the development standards for the 10-story apartment building located at the eastern portion of the development site by reducing the building setbacks and increasing the height of the mechanical penthouse. There will be a total of 7 parking spaces on site. This building will contain 92 affordable rental units, including 10 secured rental replacement units for 1339 King Street West. The existing 2.5-story detached dwelling located at 1337 King Street West, and the existing 2.5-story apartment building containing 10 rental units located at 1339 King Street West will be demolished. The existing 11-story apartment building and Parkdale United Church located at the western portion of the development site will be maintained and unaltered. This is currently being reviewed under a related site plan control application. Committee has before it copy of the plan of survey, site plan, floor plans, and elevations, covering letter from the agent, an arborist report, parking review letter, correspondence from the project engineer, site-specific zoning bylaw, and revised diagram 3 affecting the subject property. We have email correspondence from Transportation and Services and staff report from Community Planning. We have correspondence in opposition from 137 Dunn Ave.
Through you, Mr. Chair, we have the agent in person here to speak, and there are no other registered speakers for this item.
Okay, good morning, sir.
Good morning. My name is Robert Walter Joseph. I'm a principal and planner with Gladkey Planning Associates, 533 College Street, Suite 100. I will perhaps be brief this morning, if I may. We have received one letter of objection from a resident further south on Dunn Avenue. Our transportation engineer has also responded directly to them. At a very high level, I'll speak briefly to the overall application. Our client, the Parkdale United Church Foundation, has operated 136 affordable units on the property since the 1970s. At council last year, a site-specific official plan amendment and zoning bylaw amendment was advanced to for the purposes of advancing this 92-unit affordable infill building. The project is supported by the City of Toronto through the Open Door program. We have submitted in earlier this year in the spring a site plan application, which is currently under review. We have received comments, and we are also providing or imminently providing our response to those comments. At a very high level, the variance, we have several variances are requested, several of which are associated with the appropriate sizing of mechanical elements in the building. These relate to setbacks at the mechanical penthouse level, as well as a protrusion in excess of the height for access to the mechanical penthouse roof. The lower portions of the building, there's several setback variances requested regarding specific cladding on the building. These variances range between, I believe, 4 and 35 centimeters. And then further, the issue of parking, which I'll speak to in a bit more detail. We are proposing the reduction in parking of one space. This is due to the siting of a transformer, pad-mounted transformer on the property, which is required through discussions with Toronto Hydro. Currently, the pad-mounted transformer is adjacent to Dunn Avenue. There is a geothermal loop under the parking and loading area, and so this is really the only space where that transformer can be sited. Our transportation engineer noted the concerns received from the resident to the south, and also there's, I think, some additional nuance here. There is no parking requirement for this type of affordable housing or alternative housing. Through the official plan amendment and zoning bylaw amendment, for operational reasons, our client wanted to retain as many parking spaces on site as they could, so 8 parking spaces were provided. Through that, they were secured as visitor spaces. For their own flexibility, we have proposed an amendment which will see 5 residential spaces provided and 2 visitor spaces maintained. With respect to visitor spaces, which are specifically what the objection noted, on-street visitor parking is still available, but in the transportation engineer's letter, their justification does not rely on this on-street visitor parking. There is transit adequately provided on King Street. There are other overnight lots available, and there is appropriate signage and regulations on limitations for visitor parking outside of permit hours. So we believe that there is no parking issue on site. We believe overall that the variances that we're seeking are minor in nature and support good planning. We continue to work with city staff through our site plan application process, and will be secured, specific buildings on will be secured in a site plan agreement with the city.
Okay, thank you very much, sir. Panel, any questions? That was a great overview. Thank you very much. We have no questions, so we'll take this into committee.
Thank you.
Anyone want to take a crack at this one? Very technical. Dino?
Thank you, Mr. Chair. I believe that most of the variances being requested are modest in magnitude and contextually appropriate. And I also agree that the legacy apartment parking requirements are no longer in apply. And I'm prepared to move a motion.
Okay, why don't you do that?
Okay, a motion to approve the application and the variances requested. I don't think there are any.
No, didn't see any conditions.
No.
All right, motion to approve, by Mr. Lombardi, seconded by Ms. Plaitzer. All in favor? You have your approval, sir. And it's always good to see all these additional affordable housing units. Well done.
Yeah.
Okay, number 10. 215 King Edward Avenue. This is an application to alter the existing two-story detached dwelling by constructing a rear two-story addition with a second-story balcony. Committee has a copy plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, and a covering letter from the agent.
Through you, Mr. Chair, we have the agent online to speak, and there are no other registered speakers for this item.
Great. Good morning. Good morning. Hello.
Addition to improve the functionality of the home for a
Sorry,
ground
ma'am,
family.
we missed the first part of your
Sorry.
speaking. So if you could just back up, name and address, please.
Right, my name is Parisa Behnamnia, and the address is 382 Marble Place.
Just hang on a
yeah.
sec, ma'am. Panel, does anyone need a presentation on this one? Ma'am,
right.
We've read your application. We're familiar with the material. We
Yeah.
don't actually need a presentation on your application today. We may have questions, we may not. Is there anything you'd like to share with the panel before we take it in for a decision?
Yes, just to emphasize that we are not like touching the front-facing condition. We are not touching the side setbacks. So the only thing that we are altering is the rear side, the backyard property. So we are extending the building by only less than 3 meters in the first floor, and the soft landscaping remains intact. So yes, the balcony in the second floor we are adding, but the side is closed, as you can see. So there is no overviewing to the neighbors. We already talked to immediate neighbors, and to date, no concern has been raised.
Okay, thank you. Panel, any questions?
No.
See none?
No, I'll put forward a motion.
We're in committee?
Sorry.
Go ahead.
Thank you, Chair. Mr. Chair, I will put forward a motion to approve the 3 variances as requested. I see no reports and thus no conditions.
Okay, motion by Mr. Bissonnette to approve, seconded by Mr. Lombardi. All in favor? You have your approval, ma'am. Thank you. All right, we move on to item number 11, 774 Euclid Avenue. This is an application to alter the existing 2-story semi-detached dwelling by constructing a complete 3rd-story addition, cantilevered at the northeast portion of the dwelling. There'll be a total of 2 residential dwelling units on this lot, 1 within the basement and 1 occupying the 1st, 2nd, and 3rd levels. Committee has a photocopy plan of survey, site plan, floor plans, and elevations, and just 5 photographs of the subject property.
Through you, Mr. Chair, we have the agent online to speak, and there are no other registered speakers for this item.
Great, thank you. Good morning. Tomas.
Yeah, good afternoon, Mr. Chair.
Are you gonna have to speak up a little louder, please, sir, or get closer to the microphone, or turn your volume up?
Good afternoon, Mr. Chair and committee members. Is that much better?
That's much better, thank you.
Sorry, through you, Mr. Chair. We do have the agent online. We also have one registered speaker in opposition online.
Ah, okay.
Sorry, are we on?
We're number 11.
Oh, sorry.
We're good?
Yes.
Okay. All right. Name and address, please, sir.
Yes, my name is Thomas Growell, and I'm the agent for the subject property, which is 774 Euclid Avenue.
Okay, sir, hang on a sec. Panel, does anyone need a presentation on this one? Fairly straightforward, only 2 minor variances. Sir, we've read your application. We're familiar with the material. We don't need a presentation today. Is there anything you'd like to share with the panel before we take it in for a decision?
No, I can answer any questions. You guys have questions.
Great, thank you. Panel, any questions? See no questions. Okay, let's take it into committee. This is a pretty minor one. Phil?
Yeah, I'll just move this or go straight into a motion. It's a very small variance as a contextual to the neighborhood type of third story addition. So I find it to be minor. I would move to approve it, no conditions.
Okay, motion by Mr. Ghosh to approve, seconded by Ms. Plaitzer. All in favor? You have your approval, thank you. Okay, we move on to item number 12, 81 Lippincott Street. This is an application to alter the existing 2-story townhouse by constructing a rear 2-story addition and a rear ground floor deck with stairs. Also, interior alterations to construct a new dwelling unit in the basement of the townhouse. There'll be a total of 2 dwelling units on this lot. Committee has before a copy plan of survey, site plan, floor plans, and elevations, 10 photographs of trees on the subject property, a tree protection plan. We have a staff report from Urban Forestry and correspondence and opposition from 79 Lippincott Street. Do we have the agent with us?
Through you, Mr. Chair, we have the agent online to speak, one registered speaker in opposition, and if we can just confirm with Joe if Alex is going to speak, because I haven't been able to reach Alex.
Okay. All right. Mr. Dome, are you there?
Hey, Joe Dome, 133 Torresdale Avenue, agent for the owner. I would be representing this application.
All right, sir. We have someone waiting to speak on this item, so we'll need a short presentation, please.
Yes, this is a relatively straightforward application. The owners would like to construct a rear 2-story addition and rear ground floor deck and a new as-of-right basement secondary suite to the existing 2-story townhouse. 3 variances are requested. Variance number 1 refers to the proposed FSI of 1.26. The 4 immediate townhouses exist on tight lots. An impact here is mitigated by the fact that the existing dwelling has an FSI of 1.09. And the proposed addition is 26.62 square meters in size, extending no further than the location of the existing rear wall of the main floor. The proposal does not impact the streetscape, and the dwelling itself complies with the bylaw for side yard and rear yard setbacks, and no soft landscaping variance is required. The attached neighboring dwelling at number 79 has an FSI at least equal to and likely larger than 1.09, and the second story extends further to the rear than the existing second story of number 81, as can be seen on page 6 of the submitted arborist report. If we could bring up page 6 on the arborist report, it does show the rear conditions of the dwelling.
Do we have the arborist report?
It should be
The tree protection plan?
The arborist, the arborist report, page 6 should show it. I believe that is that's
I
not
don't
the
see the arborist report in the
page.
materials. Sir, we don't have, do we have it?
I believe it's 1 page up. So this is the document. It's on a different page, 1 page higher than this, which should be page 6. So that shows the rear of the existing dwelling. It does show also the rear of number 79 as well. It does show that 79 has a second story that does extend further, and the existing FSI of the current dwelling at 81 is 1.09. The dwelling is at 79 is tenant occupied, and is also, which also on the photo has a second story deck. So the proposed second story addition at 81 would also help to improve privacy conditions, and as well as can be seen in the photo, there's a third story deck on the neighboring dwelling as well that stepped back. And the proposed FSI is not out of character with the street. For example, at 107 Lippincott, approximately 65 meters to the north, which is a three-story detached dwelling. It was approved in 2014 with a 1.25 FSI with a GFA of 250.39 square meters as opposed to the 135.53 square meters proposed in this application. So the FSI increase is quite reasonable, and variances 2 and 3 refer to the proposed rear deck 0 meter side yard setback, encroachment to the rear yard of 0.63 meters over the bylaw, and rear deck stair width of 3.39 meters. And this is a modest deck increase that will increase enjoyment of the space, and smaller in scope than the total deck space of number 79, which does have a sizable deck that does the main floor that does extend deeper toward the rear, toward the south side of the property, as can be seen on page 11 of the arborist report. And it also, as I mentioned, has the second and third story decks. The owners had reached out to neighbors, and yesterday the owners had received a letter of support from the north attached neighbor number 83, and we have submitted it to the late file. And we are aware of the comments from the south attached neighbor at number 79. And as I mentioned, that dwelling currently has a second story that extends further than the existing second story. So the proposal would be relatively similar to the built form there. There were a number of construction-related objections that would apply to any proposal. Overall, planning staff have no concerns, and we feel the application is reasonable and minor in nature and in character with the street. And I'd be happy to answer any questions you may have.
All right, sir. Thank you very much. Panel, any burning questions before we hear from the speaker? None? All right, let's have our person in opposition.
Good morning, Julian. You have been unmuted.
Good morning.
Can you hear me?
Yes, we can. Name and address, please, sir.
My name is Julian Herbert. I'm the owner of 79 Lippincott Street. I reside at 12 Barber Avenue, though. The 79 Lippincott is my tenanted property. I used to live there years ago. And we share a partition wall with 81. The current tenants have notified me that they intend to vacate the property due to what they expect to be a very long construction process, which will involve basically demolition of the rear third of the house to basically rebuild it wider towards 83 Lippincott and extend the back of the house of 81 Lippincott as described, and then adjoin my partition wall, which is an exterior wall at the moment. So my opposition is primarily to the, I believe that's the first variance, which is 1010-4041A regarding to the increase in floor space index to 126%. And that's mainly coming from the addition on the second floor towards the back, but also largely to the side going towards 83, which is what's causing the third of the house to be demolished. And the tenant's concern and my concern is that with this scale of work to widen the house, we're in for major construction, A lot of this will be on a partition wall, and we're talking about below grade work, vibration, noise, and also that we don't quite understand how this is even constructible since the backyard doesn't have access to any road or laneway. So I'm not quite sure how heavy equipment would even get back there to do footings for piles. And then there's also concerns around the existing partition walls basically not being anything close to standard or code. There's no fire protection. They're basically just wood framed walls with no filler. And there is, so I expect the tenants, or they've indicated to me repeatedly that they expect to vacate for this project. And then I'll be left to try to rent this property with this big construction going on next door, which I expect will leave me with significant financial losses. I'm not a multi-property owner. This is my only rental property. And I've tried to reach out to the owners to find ways to mitigate the damages, but the only response I've received so far is that we'll talk about it at committee. I'm not opposed to renovations. I'm just opposed to tearing down a third of this house. And then there's, if I have the time, there's another issue that doesn't directly affect me, but I think is a safety concern. And that's towards 83 Lippincott. So that would be the other side of 81. And by pushing the exterior wall out to the property line, what will be formed is an enclosed tiny courtyard, which will be virtually inaccessible from outside. If you're able to go back to the site plan drawing.
Sir, I'm just gonna, I mean, those are issues that are related to another property, so not sure, and that property has not corresponded with us, so.
But I'm concerned it's a safety issue for the residents, which is mainly operating as a rooming house.
Okay.
So I spoke to the zoning evaluator, and basically I think it hasn't been flagged because there is a small 3-foot part of 81 that is already on the property line, which gives them an exemption, but isn't really, in my point of view, in the spirit. You can now scroll back up. You can see it written, you can see it just under where it says new 2-story addition. And that little section to the left there, that gives them, the existing part gives them the exemption to build right to the property line, but it forms now a 10 to 12 foot alley that is, I don't know, a foot wide. Like, I don't think you could get through there. So, and then the other house
Okay,
sort
sir,
of
I'm
operates.
just gonna ask you to conclude. You're past your 5-minute time.
That's pretty much what I wanted to address in summary. Is my concern that there will be significant financial losses on my part because I won't be able to rent this space. And that's driven mainly because of a 120%.
Okay, thank you, sir. I feel obliged to bring to your attention a lot of the matters which you've raised today are beyond the purview of the Committee of Adjustment. So many of the issues you raised would be addressed subsequently through the building permit stage. So we can only deal with the issues that are related to the variances before us today. So, but we will ask the agent to try to address the concerns that are related to the variances. Thank you.
Yeah, part of my problem was I only had about 10 days to review this.
Yep.
Yeah.
I understand. Thank you very much, sir. All right, can we get the agent back, please?
Yes, and we do appreciate the comments. But it is my understanding that the owners have reached out to the neighbor going back originally to April, and that they have had a number of discussions about this proposal. And as far as the widening is concerned toward number 83, I would just note that we do have a support letter from number 83 that we received yesterday, and we did submit it to the late file. They don't have concerns with impacts to their property. And the side yard setback is as of right as well. The demolition itself, the concerns regarding demolition or construction related issue as mentioned, that's will be dealt with at the permit process. Demolition was not based on the width expansion. It was considered before and was based on the poor state of the condition of the existing structure. Essentially, we do feel that the proposal is quite reasonable.
Okay, thank you, sir. Panel, any questions of the agent? Okay, we don't have any questions. Thank you very much. We'll take this into committee. Ryan?
Yeah, I understand renters not wanting to stay during a construction period. I've lived through neighborhood construction, and you know it's not pleasant. I understand a landlord doesn't want to lose rent-paying tenants, but this can't be a reason for projects and renovations not to proceed. You know, the chair mentioned a lot of the concerns brought forward by Mr. Hebert or Herbert. They're valid, but they're not matters that this committee decides on. In this case, we have 3 variances before us. I find them all supportable, and I'll be voting to approve.
Okay, anyone else want to speak to this, or Ryan, do you want to take a crack at a motion?
Yes, I will move a motion forward to approve all 3 variances. Is there a forestry condition?
No, the
No.
forestry, it's listed, but it didn't have any
Yeah.
check
Okay.
marks, so
Okay.
I think we're good.
Yeah. Yeah.
All right, motion by Mr. Bissonnette to approve, seconded by Mr. Lombardi. All in favor? The application is approved. Okay, we move on to item number 13. 37 Roxborough Street West. This is an application to legalize and maintain the existing rear basement walkout entrance, the rear ground floor deck with stairs, the rear 3rd-story roof deck, which are all constructed beyond the limits of an authorized building permit. There will be a total of 2 residential dwelling units on within the existing 2.5-story semi-detached dwelling on this lot. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, red line public notice from the agent, 4 photographs of the subject property. We have a covering letter from the agent, previous decision numbers affecting the subject property, an OMB decision affecting the subject property, several decision numbers affecting neighboring properties. We have an OMB decision affecting a neighboring property. We have presentation materials from the agent, received December 4th and December the 8th. We have order to comply for the property. We have 30 form letters in support from owners, occupants of properties on Roxborough and Gibson. We have correspondence or 15 form letters in opposition from owners and occupants of properties on Roxborough Street West, and materials in opposition from 39 and 35 Roxborough Street, and something from no name provided, no address provided. Good afternoon, sir.
Good afternoon, Mr. Chairman, Franco Romano. Through you, Mr. Chair, we have the agent here in person to speak, and we also have 2 registered speakers in opposition present to speak.
Now, Franco.
Thank you. Thank you, Mr. Chairman, members of the panel. Good afternoon. Franco Romano, Action Planning, 321 Lakeshore.
Great. We have some folks that are here to speak, but also this has a fairly substantial track record with the committee and other applications, so we're going to need a presentation to kind of try and explain it all and put it all together. Plus, you've got orders to comply, so
I do.
it's a big chore.
Five minutes.
Try and get that in 5 minutes. Given this complexity, I may grant you a little bit of extra time.
Much appreciated. And I feel my chair is falling down on me, so if I Oh, I'm ready to roll. So if staff can bring up my presentation material, please. There should be 6 slides associated with it. Slide 1 shows a present variance request, reflects a long-standing condition that has been in place for over a decade as it relates to the rear ground floor deck. That's the left-hand side air photograph, and the right-hand side air photograph shows a post-2012 condition that relates to a 2013 building permit construction that occurred, as well as sign-off that occurred. The related OMB approval had a condition to construct substantially in accordance with the drawings, and the city accepted the platform under those conditions. The rear yard landscaping is a new proposal in front of this panel today. We will see on this air photograph that there are current pavers back there. The proposal is to replace those paving stones with soft landscaping. At the time of the building permit ranging from 2012 minor variance to the 2013-2014 sign-off on the building permit, we're dealing with the former Toronto zoning bylaw 43886, which did not have a rear yard soft landscaping zoning regulation. Bylaw 43886 had a total lot area requirement of landscape open space, not the same definition, but it required 30% of the entire lot to be landscape open space. And landscape open space under the former zoning bylaw included certain elements of hardscape. The property with those paving stones fully complied with the applicable law, the applicable zoning bylaw that was in effect at that time. What we'll see in terms of slide number 2 is that the surrounding area, and I just concentrated on the south side of Roxborough and on Gibson to the rear, shows surrounding lands have a diversity of rear yard soft landscaping, and it is common for properties to have little to no rear yard landscaping. The table there that is provided also in a separate supporting document shows landscape provisions that have been approved, authorized by the Committee of Adjustment from 0% to about 45%. I'm not going to go through each and every one of them, but it's quite common for new construction to have that type of condition. If we jump to slide number 6, please, and appreciate staff that I'm jumping around a little bit. Slide number 6 shows the rear deck condition along Roxborough, and it's quite common for decks to be located at the rear of a dwelling. This is a neighborhood where decks are located not only on the ground floor, they might be at grade level, they might be at the ground floor, they are at the second floor, they are at the third floor, and there are rooftop decks. There are also ancillary buildings with rooftop decks. So it's quite common to have this kind of condition. The proposal maintains the existing deck and with setbacks that are similar to what is found within this neighborhood. The proposal, if we can go to slide number 3, please. The proposal is to permit the existing rear yard deck to be maintained and to permit a reduction in the rear yard soft landscaping. Again, that would be an improvement. The proposal originates from city inspections after a complaint was filed after the May 2025 Committee of Adjustment request for a front elevator addition. What happened is that city inspectors attended the site after that refusal. The elevator addition is no longer being proposed at the front. There is a building permit that's issued that places it at the back, consistent with what the previous panel largely differently constituted than what's here, than the people that are here today, and what some residents asked for. The city issued building permit documents for the existing rear basement walkout entrance, third floor deck, and the second dwelling unit. So many of those items that are in the purpose of the application that's in front of this panel today are addressed. The only variances that are associated with what is described in the purpose of the application relates to the platform at the rear of the ground floor and the rear yard soft landscaping. If we go to slide number 4, please, we'll see that this is the site plan, and I'm showing in green the location between the existing rear deck and the ancillary structure that is going to be changed from patio stones to, and I apologize for going over. I'll try to be as
Yeah,
quick
please
as I
continue.
can.
Yeah.
To change from paving stones to soft landscaping. The land area in the rear yard that's included in that calculation goes from the rear wall of the dwelling to the rear lot line. So that's a large area, so anything associated with a deck is included in that land area, but can't be included as soft landscaping. Same thing with the ancillary structure, same thing with the driveway associated with it. In terms of the west side yard setback, we'll see in blue on that slide, light blue and dark blue, where the setback for the deck is a variance, and as well in brown, the setback for the stairs for the deck is a variance. So both of those maintain the general intent and purpose of the zoning bylaw to accommodate an appropriate access and position for the rear platform. And the rear soft landscaping represents an improvement over the existing condition and facilitates appropriate condition in this neighborhood and percolation, and again, that is an improvement. So I would submit that the proposal satisfies all 4 tests for a minor variance, and I'm happy to answer any questions relating to the orders to comply or anything else in addition to the history.
Great, thank you, sir. Phil?
So just a very quick question about the planning request that the paving under the platform be replaced with permeable pavers. Is that something that you'd noticed and your clients are willing to comply with?
Thank you for that question. Through you, Mr. Chairman, I have not seen a planning request.
Oh, can we pull, is there a planning report?
Am I remembering or?
Hang on a sec, let's just see. I don't see a planning report.
I must have confused it with a different application.
I didn't see a plan.
Okay,
Thank
well,
you.
so I answered my own question.
So you're changing, I see, you're making an amendment that changing the purpose of the application.
No, sir, I submitted that, and thank you for that response. When I saw the draft public hearing notice, I provided my comments to the Committee of Adjustment. Committee of Adjustment returned that they're keeping the purpose of the application as they drafted it, and I'm not providing any further comments in that regard.
Oh, okay. I have a stricken out version of it in front of me.
I did submit that for staff when they provided a draft.
Oh, I see.
And
Okay,
they-
gotcha.
And the Committee of Adjustment said that they were keeping the purpose, and I'm providing no further comment on that, so I'm not making any amendment.
Okay, so there really isn't a red line public notice on this one?
No.
Okay. Yes, Dino?
Thank you, Mr. Chair. I'm taken aback a bit because this is the first time I'm seeing Mr. Romano in person for almost 6 years.
Yes, sir.
He's been before the TLAP many times. It's nice to see you.
Good to see you.
Has bylaw 43886 been dealt with by the OMB? I mean, it's 569/2013, it's 13 years later. I know there's some areas in the city where the bylaws are still in place, the former bylaws. Some areas in the city, they have no bylaw.
Through you, Mr. Chairman, the way I'm gonna answer that question is that the City of Toronto has a practice of never repealing a zoning bylaw after a new one gets adopted. So 43886 is still out there.
Is it
Just
superseded
as-
by the new one?
It's still out there. It's still, 43886 is still a bylaw that is it is not being repealed, just like and I'd have to look up what the number is of the previous bylaw before 43886. That one's still out there. It's 29216 or something like that. What happens is, in terms of practice, is that if I submit something today, which is what happened today, under this circumstance, there is a building permit, there is an order to comply dealing with certain items. The owner responded as quickly as possible, doing the architectural, the structural, et cetera, submitted a building permit application. The building permit application then gets reviewed under today's applicable law. And
Right.
today's applicable law is for the zoning bylaw is 569-2013. So that is the in effect zoning bylaw.
Okay.
It's quite common
Yeah.
that conditions in a neighborhood such as this, which is an older neighborhood, that certain aspects that have been constructed get grandfathered, so accepted as an existing condition. In this case, there are certain things that have been accepted. The rear platform and the soft landscaping have not been accepted as existing
All right. Thank you.
conditions, and so we're before
Thank you,
this
Frank.
panel asking
That's
for those variances.
Very helpful. And this panel has often seen duplicative variances, right?
Yes.
Pointing to two separate bylaws, and that is the explanation for it.
Yes, sir.
Thank you
Yep.
very much.
You're welcome.
All right, let's, thank you. Let's hear from our speaker. How many, so we have, how many speakers do we have today? Is there 3?
Well, I'm here, Judy
Oh,
Bloomstock.
hang on a
Can you
sec,
hear me
ma'am.
okay?
Yep, we're gonna get to you. Hang on. All right, sir. Welcome. Your name and address, please.
My name is Paul Bravi. My address is 35 Roxborough Street West. I'm the property attached to 37 Roxborough. That is not my presentation, so if we can get mine up, I'd appreciate it. Mine starts with, oh, sorry. That's the one.
All right, sir, you have 5 minutes.
Thank you. First, let me address the false narrative being circulated today. In Mr. Romano's presentation, he refers to my deck and my property. I just want to be clear. My deck is different than the one in question here. My deck does not span the length of my property. My deck does not straddle the property line with me and my neighbor on the east, encroaching on their privacy. And my deck is legal and was built with a permit. The planner references me and 61 Roxborough as examples of this type of build. And he references A0439/07TEY as part of the history for this property. My deck is set back by 4.5 feet from my neighbor, and 61 that is referenced doesn't even have a deck. And as we can clearly see from the aerial photos that the planner has provided. And to cap it all off, A0439/07TEY is for Roxborough Street East, the wrong property. Secondly, this application is built on misleading and inaccurate plans. The applicant has repeatedly presented conflicting plans to this committee, obscuring the true nature and scale of the proposed changes. On page 4 of the presentation, you'll see deck sizes were misrepresented at the Committee of Adjustment meeting on May 28th, which took place only 6 months ago. And on page 5, as you can see, the third floor deck labeled as built today in today's application does not match what is actually there. Additionally, critical changes such as a third floor addition and elevator are entirely omitted despite open permits. There were also 3 open violations and ongoing construction. The proposal blatantly contravenes an OMB ruling. That ruling from May 2013 regulated deck size for this property, and the owner has totally ignored those conditions. And let me be abundantly clear. The owners of 37 knew exactly what they were doing back in 2014 when they built these decks in the illegal apartment. They had just spent tens of thousands of dollars on lawyers and planners and architects appealing a Committee of Adjustment committee. And on page 8 of my presentation, you can see what they told the OMB they would build versus what they built. And the owners and engineer, so he knew exactly what he was doing. Even their present planner on May 28 confirmed to this committee that the OMB decision regulated deck sizes. Today, no mention of it. The owners of 37 took the opportunity with me as a new owner to ignore the OMB ruling. We only discovered this on May 28, 6 months ago, when once again they tried to deceive this committee by presenting false and inaccurate plans. I say deceived because both the owners and the planner knew the plans they put forth were false. They failed to disclose their illegal decks and avoiding questions about the illegal apartment and showing a Passover kitchen instead of an illegal apartment. So at what point can we trust what they present? This is not a minor oversight. OMB decisions are not suggestions, they're legal obligations. And catch me if you can is no way to perform renovations. And I lived with these illegal decks for over 11 years, right? And now they're saying that as if nothing ever happened. There are other issues. Even though residents only had 2 days to respond, the adjacent neighbors, which include 2 city planners who understood the issues, The false narrative, the privacy issues, and the extent of the illegal builds have voiced strong opposition. In fact, 2 neighbors asked the owners of 37 to withdraw their letters of support, which wasn't done. One of those neighbors, Lindsay Dale Harris, a prominent city planner who had to personally send her a retraction letter because the owners of 37 got a signature from her housekeeper. Zoning and legal status have been disregarded. The deck height, setbacks, and stairs all exceed legal limits. The privacy fence that sits on 35, my property, sits at 8 feet 6 inches tall, taller than allowed, with no variance request. Soft landscaping requirements remain unmet. An illegal basement rental apartment exists and continues to be undisclosed and occupied contrary to building code orders. And grade issues have created drainage problems for neighboring properties. And also no engineering report has been provided for the deck's integrity. The owners of 37, please go to page 11, sorry. The owners of 37 have a history of ignoring basic privacy expectations. They built this deck illegally, affecting privacy on both the east and the west. They built a 3rd floor deck illegally, affecting the very personal privacy of my bedroom, as you can see from the pictures. And they built a deck on the garage that looks directly into our kitchen. This application, if it's approved, will remove all guardrails for privacy expectations and future deck sizes. There is no compelling justification for this variance other than it already exists. They also want to pick and choose which bylaws they enforce. Old bylaws for the deck and new bylaws for the 3rd floor expansion and basement apartment. And even if we were to revert to the old bylaws, there's always an ONB ruling. You can't have it both ways. If we allow this, we send a message that rules are optional and those who break them won't be asked to correct their violations. So in conclusion, the proposal fails to the 4 tests for a minor variance. It is not minor, it's not desirable, it's inconsistent with the official plan and zoning bylaw, and it sets a really bad precedent. Compliance should be enforced unless a unique hardship is shown, which is not the case. I also, and this is a big ask, I also respectfully ask the committee to use all its powers to put a stop on the current approved permit build until all matters related to the violations have been corrected, until such time as the owners of 37 respect all bylaws and the OMB's decision. Thank you.
Thank you very much, sir. You've raised a number of issues, technical and historical and relating to bylaws. I think what I heard you say, one of your biggest issues is really the privacy issue. You know, overlook, I guess, and lack of privacy. I thought I heard you say something about a privacy fence that's in between you and the neighbor. Is there a privacy fence there now?
No, if you go to, I don't know what page, if you go on my presentation, you go down. On 35, they have a tall, an 8 foot, 6 inch, it's a small section of fence right there. So the tall one is theirs, it's only about 2 or 3 feet wide, the other one is mine, right? So.
Oh, so you put the fence up between?
I put one that's at legal height, they've put one that's an illegal height. It's higher than that,
Okay.
right? So it's not even mentioned here, but that's way too high
Right,
also.
I'm just trying to get a feeling for your concern
And
about privacy.
fair. And then when you look at, there's also a picture there where you, oh no, that's the illegal apartment, so right there in the middle. What you see there is not on my property, that's on 39. That's what she stares at. She stares at a fence and she stares at a deck which is on her property line, or just 0.3 meters, whatever it is, on her property line. That's her view, right? So the whole point that setback is what we're talking about. That setback is what they're asking for the variance at. Move it 3 feet in. Move it for, like, why? Why would anybody put their deck all the way to the property line overlooking your neighbor's backyard? Okay. And they did this without a permit, they did this illegally, and they did this contrary to an OMB decision that regulated their deck sizes. The ruling said, here are your decks. They only got a permit in 2012 and 13 because they agreed on the smaller deck sizes. Otherwise, they would never have gotten that original permit.
All right, sir, thank you. That's very helpful, explains it. Yes, Guillaume.
Thank you, Mr. Bobby. You have a concern with the size of the deck and the fact that it's not as per UMB decision.
I have a concern with the size of the deck. I have a concern of that these decks have existed there illegally for 11 years and have been impacting. I'm very passionate about it.
I understand
it's
completely.
like we just found out about this, right? I moved to Toronto 11 years ago, and I thought it was all good and dandy, and it isn't, right? So.
Okay, so if you're looking at the variances being requested today, there's no variance for the deck size, any of the decks. It's setback.
Definitely.
Pretty good. And I'm looking at the OMB decision that's in the file, and the terms of settlement don't necessarily outline the size or dictate the size of the decks. It basically says, item number 2 says, revised set of drawings showing the reductions in the size of the decks. So the size of the decks that were approved as part of the settlement would be shown on the revised set of drawings.
Which are attached to the OMB decision.
So-
It's there.
So what are you suggesting that the deck that is shown on the attached set of drawings to the OMB decision, the deck that you referred to, are not the same dimensions?
So let me go to the page. If we can reference page 8 of my present, that's not my presentation on, sorry. So on the left-hand side, you see on page 8, the top is what the plans that were attached to the OMB ruling in 2013. And the bottom is what they are presenting today, as built. That as built was done in 2013. So if it's not today, it's not recent, right? They had that decision, they knew what their legal obligations were, and this is what they built. And the same thing for the third floor. Even though the third floor may not be part of this, look at the third floor, that little on the right-hand side, the little blue thing in the middle, that's the deck they agreed to build. That's the deck on the bottom, what they actually built.
Last question. And so the plans that were submitted as part of this application were reviewed by, I believe there's a zoning review. The deck size was not a consideration or a red flag in terms of a variance requirement.
I have spoken to the zoning review department many times. I cannot get an answer as to why we are where we are and why they are not taking that ruling of 2014 into consideration.
2013.
2013, I apologize, 2013 into consideration. They won't tell me anything, it's all protected under freedom of information, so I don't know. My issue is, there's a legal ruling, that's not an opinion, right? That's,
Right. And they're not here and we can't ask questions of them, so thank you for that.
All right, thank you very much, sir.
Thank you.
Appreciate it. I think the next speaker's online.
I do have,
Hi, Judy, you've been unmuted.
thank you so much.
Oh,
Yes,
hi,
I'm
ma'am.
here on,
Your name and address, and if you could just speak a little louder for us, please.
certainly. So my name is Judy Bloomstock. I'm the neighbor at 39 Roxborough Street West,
All right,
Toronto.
you have 5 minutes, ma'am.
Can you come on? Okay, great, thank you. So I did prepare some slides. I wonder if you could pull those up. There's 6 slides. I can't see because I'm just on the phone, so if you could just let me know when slide 1 is there, that would be great.
Yeah, we have the title slide. There it is, slide 1.
Okay, thank you so much. So I'm calling in to oppose the ground floor deck as it is built, and I prepared these slides to describe what the issues are from my point of view, so I'm the neighbor immediately to the west. So my comments focus on the ground floor deck that was built across the backyard of 37 and spans from east to west. As a previous speaker mentioned, this goes against the 2013 OMB decision, and I actually put the wrong decision number in there. So it should be A071912TEY, which specified a deck of a certain size with setbacks from the neighbor's yard. So apologize for that incorrect number, but it is A071912TEY. If you could go to the second slide, please.
Yep,
Is that
there
up?
it is.
Okay, thank you. I just can't see, as I mentioned, I'm just on the phone. But the agreed upon depth was 12 feet in depth, and it was set back, as you can see in the diagram, from the neighbors to the east and to the west, 35 and 39, which is me. The blue shading shows what was authorized, and the pink shows what was actually built over and above that. So next slide. The most important point regarding my privacy here is the deck fence on the west side, which abuts me, is 0.15, within 0.15 meter of the property line versus the required setback of what I understand is 0.9 of a meter, according to bylaw 569/2013. And the deck has a 6-foot high fence, which extends along the fence between 37 and 39, again, right up against the property line. Slide 4, please.
Okay.
So as you can, thank you. So as you can see in this drawing, having the deck straddling all the way to the property line with the stairs that run up and down from it creates a problem for 37 getting from the front to the backyard. The neighbors at 37 are now building an elevator at the back of the house, and they've moved it from the front, which is great. But now they need to use the shared walkway rather than their backyard to move material from the front and the back. So those stairs and the deck, if the deck had been properly set back, this would not be causing that problem. Slide 5, please.
Okay.
This diagram just really shows the way the deck in pink spans the property. This is a very unwelcome precedent for privacy and for light. And if you note that the deck on 35 to the right is properly set back on the east side. So there is no precedent for this, as far as I understand it, running all the way across the property line. That is why the bylaw exists. Slide 6 just shows how the high fence looks from my side of the yard with the deck right up against the property line. And I just want to conclude by saying the neighbors have brought about multiple projects with disregard to the OMB and other regulation, let alone the impact on the neighbors. There is a legal basement in the property. It's completely wrong, and we're dismayed that the city is permitting this sort of free-for-all regarding construction. Just very dismayed that the bylaws and the OMB decisions need to be respected, especially as regards this level of privacy. We're already very, very close in this neighborhood, and the bylaw is to protect whatever little privacy we may have. Thank you.
All right, ma'am, thank you. Panel, any questions of the speaker? See none? All right, that's it for our speakers. So we have the agent back. We did have a Kevin Doyle.
He's unable to.
We lost him? Okay. All right.
Let us know that he won't be able to stay.
Okay. All right, Mr. Romano.
Actually, staff had the previous. If you go up one page, the survey, yes, perfect. And if you can zoom into the back, excellent, terrific. Not that it's a little too much of a zoom there. Perfect. Yes, thank you. So thanks to the residents for their comments. This is a survey that staff have kindly brought up for me, and you can see the property that's in the middle says wood deck. That is 37 Roxborough Street West, and you can see that it's the deck projection and its width. And the property to the right is number 35 Roxborough, and you can see that is correct, that they have an east side yard setback, but there is no west side yard setback to their deck. Stairs are right up against the lot line. The two decks are strikingly similar, where there is a difference, so they align in terms of projection. They're very similar in terms of the size. Where they differ, they also, if you recall slide 3 of my presentation slides, in terms of the height of the deck, they align perfectly. So they are exactly the same height, and you can see that in the middle photograph on the right-hand side, where the decks align. Where there is a difference is that where height is measured for the platform is next to where the platform is located. So it's not from the front yard, it's not from anywhere else, it's what's happening to the grade around the platform. So the deck height is off of the ground floor for the subject site, but it's at that 1.94 meters or whatever it is. If we go back to the survey, we'll see that number 35 has a lower grade elevation in the backyard, and just above the 13 there's a geodetic elevation of 114.59. And just behind the rear wall of number 35, there's a deck geodetic elevation of 118.92. Their deck, Mr. Bravi's deck height pursuant to bylaw 569/2013 is 2.33 meters. There is no variance authorizing either that deck projection, because it projects the same as the deck on the subject site, nor a deck height of 2.33 meters. I've looked. Hatch Designs has also looked and investigated previous decks. It is a common condition in this neighborhood to have decks that are not fully zoning bylaw compliant. The proposal is a deck that is in keeping with the surrounding neighborhood, respects the existing neighborhood, and has dimensions that reflect the site in terms of the height. But the ground floor at the front of the house on 37 is at grade, and as one goes to the backyard, the topography drops. In terms of, so I would submit that what is being proposed here is in keeping and consistent with the neighborhood character. And just to finish off the point on number 35, I heard Mr. Bravi say that it was inconsistent with a building permit that was issued. If that deck is consistent with a building permit that was issued, then my client should not have to go and get a building permit or the variants that are in front of this panel for their deck, because it's virtually identical. But my client has been required to come in front of this panel to ask for variances, and that is why we are here. I noticed no objections to the rear yard soft landscaping, so I'm just going to stick with the rear deck. The OMB decision of 2013 says the alterations to the dwelling are constructed in substantial conformance with the drawing shown in attachment 1. Operative words, substantial conformance. Who is the authority to interpret what substantial conformance is? The City of Toronto, when they dealt with building permits. They dealt with the building permits through that 2012 to 2014 sign-off. That deck has been there for that long. The sign-off was provided. The proposal complies with the condition because it is substantial in conformance. They're not exactly the same, I agree, but they are in substantial conformance. And as one of the panel members asked one of the previous speakers, there was no deck size variance. In terms of the privacy, there are privacy screens. If we go to slide number 3, you'll see privacy screens on both sides. Through my client has never heard an objection from number 39 relating to the privacy screen on the west side until today. So that my client is prepared to move that privacy screen and have it located about 0.71 meters or 28 inches from the west lot line. As a registered professional planner, I don't believe that's necessary. My client is ready to move that privacy screen in order to further mitigate. But it's my opinion that what is permitted as of right and what is proposed, the mitigation is provided, it's in keeping with the neighborhood character, and it satisfies all 4 tests for a minor variance. Thank you, Mr. Chairman.
Thank you, sir. Both neighbors have spoken about the OMB hearing, and you've tried to address it. The hearing, even though we all understand what substantially in compliance means, but was the decision tied to drawings?
Yep. The decision is, and I was the planner at that hearing. So.
Yeah, and while you're thinking that, like, was the current owner the owner back then, or has it been
Yes.
changed hands?
Yes.
Okay, it's current.
No.
So if you can just, I'm trying to figure out, because what the neighbors have said is they've shown the drawing, and the drawing appears, at least from looking at it, significantly different from what was in the OMB hearing. So did the OMB tie the approval, substantial approval, to the plan?
Yes, thank you for that question. Again, I'm reading right from the decision at the end. It says the alterations to the dwelling, because it was a building addition that was being proposed. The alterations to the dwelling are constructed in substantial conformance with the drawings shown in attachment 1. So attachment 1 has a site plan, floor plans, the building,
shows the
the
deck.
building elevations. And
Right.
it shows a deck, it shows everything that a site plan would show. So, again, the approval authority to implement what substantial conformance is that building permit. It's at building permit stage. And the staff at the building permit, and this is back to the 2012 this 2013 OMB decision is related to the 2012 building minor variance under 43886. So the building permit and the construction of the deck was signed off by city staff. Not only a building permit, but then sign off. The building permit was closed. There is no order to comply related to that 2014 construction that got signed off, is consistent with substantial conformance with those drawings. So there is no issue relating to what those drawings showed in the OMB decision and what was ultimately constructed. It's substantially in conformance with the drawings attached to the OMB decision. There is no issue. So the description that Mr. Bravi has said that it's constructed illegally is, in my opinion, incorrect.
Okay, thank you. Dino?
Thank you, Mr. Chair. I'm just looking at the order to comply that was issued by the city July 4th, 2025, and it talks about the description and location. The first item is the rear deck on the ground floor, and I'll read it. Has been extended towards the west side with new dimensions of approximately 6.10 meters or 20 feet in width by 3.66 meters, 12 feet in length, extending to the property line with the benefit of a permit. So are we here as a result of your client applying for a building permit for that deck to legalize it and maintain it?
Through you, Mr. Chairman, the order to comply required a deck permit to be provided. If you look at the required action and compliance date on that same OTC, it says submit plans and a complete permit application no later than July 18th, 2025, and obtain a building permit by July 31st, 2025. Alternatively, remove the unauthorized construction by August 8th, so a bunch of deadlines. So the building permit was submitted for the deck, and that's where the zoning advice came back that we're in front of this panel for.
Yeah, thank you.
You're welcome.
All right, any other questions? Thank you, Mr. Romano.
You're welcome.
Okay, we're in committee. Who wants to start us off?
Okay, so it's an odd one. There's no doubt about it, and it's hard to. It's almost hard to parse exactly what's happened here with the OMB decision is clear, but then if it was permitted at that time, it seems to have been accepted at that time. And what almost is bizarre is actually in order to comply, if it had been permitted in 2013 as being considered in substantial conformance. So that's the part that to me is a mystery. But I can understand the frustration of the neighboring homeowners at being presented with something that to them shows not complying with an OMB decision. But what we're hearing from the agent suggests to me that maybe it was reasonably complying with the OMB decision if a permit had been issued back in 2013, because we all know that substantial accordance is something that the building department looks at when they're doing their building review, and can be interpreted slightly differently. And if you look at the actual wording of the OMB decision, it's not restrictive in a way that would say that this deck is inappropriate were it not for the fact that it was tied to plans. So all of that being said, that's me trying to untangle a knot that's led us to have this unfortunate dispute between neighbors that are attached and are going to have to live together. But if we look at it from a variance perspective, as if it's coming to us de novo, this is what we have before us, is this deck a minor variance or not? That's how we're supposed to look at these things. And, you know, if I do consider it from that perspective, I look at the plans, I look at the rear soft yard landscaping that's proposed, I look at the deck. I don't actually find it overly encumbering on the neighbors. And I don't find it all that different. You know, if you go up and down this lane, you see a lot of decks because of how this lane is, you know, quite attractively in further down, right, this behind Ramsden Park, but throughout the entire laneway, you see a lot of this. So I think it's supportable, and I wish there was even more for us to say exactly what happened to bring this here to give satisfaction to the members of the public that are, you know, understandably upset. But in terms of our duty, I think it's supportable.
Thank you. Dino?
Thank you, Mr. Chair. I agree with Philip's comments. My concern related to variance number 2, and specifically the projection of the rear, the ground floor deck, 5.82 meters, which is 19 feet from the rear main wall. And I wrote in my notes that I was going to wait till to see if Mr. Romano could convince me, and I believe that through his testimony today and the materials that he's provided, he has done that. I agree that looking at what we have in front of us, which are the 4 variances, I agree with Philip. I think they're supportable.
Okay, a couple observations. So this deck has been there for 11 years, even though it is a non-compliant with the current bylaw, but it has been there for 11 years. And I fully appreciate everyone who is fortunate enough to own a home has a neighbor, and it's really important to have cordial relations with your neighbor. This has clearly become a difficult issue between neighbors, but it has been there for 11 years. And if there has been an impact, then that impact has been around for that long, and one would think that it would gotten over it, for lack of a better word. And I personally, I accept the perspective that this is not an uncommon approach in the neighborhood, where there's small lots. Many houses have constructed decks very similarly. Many of them probably are non-conforming. That doesn't excuse a non-conforming deck, but it helps to explain it. From a privacy perspective, I'm looking at the site plan. There is a rooftop deck on the garage. I would think that would probably piss people off more than the deck coming off the house in terms of privacy, but that's not before us. I am a little bit concerned about the soft landscaping, even though the applicant has indicated that they're going to pull some pavers and put soft in there. Still pretty light. And just looking at the site plan, I'll put this up for members' consideration, there is a walkway around the garage. And if that could be either green or permeable, that might help us a little bit in terms of expanding the breadth. And I would acknowledge that, again, the prevailing pattern in this neighborhood is probably many, if not most, houses probably don't conform with the rear yard landscaping at all, but given that it's before us, there may be at least an opportunity to make it a little bit better. if the panel members are inclined to support this application. I'll just put that out for your consideration. If we're
Okay.
leaning towards supporting this application, one option would be to bring the agent back and just have a discussion with him about that.
Sure, why don't we do that? So we're talking about the landscaped walkway that's beside the
Yeah, I don't
garage.
know what, like,
Whether that would be,
I don't know what
whether
that
it would be
means, but-
acceptable to construct that with permeable pavers, perhaps?
Or maybe even grass. So I'm just gonna beg the indulgence of the committee. We'll go out of committee. If we could recall the agent.
Could I please ask staff to put that on the screen? Thank you.
It's in the agent's presentation material. So, Mr. Romano, you've heard a number of comments from the panel members. And one consideration is to do a little bit better on the rear yard landscaping. And your site plan shows that one there. Your site plan shows a walkway beside the concrete garage, or the garage, concrete block garage, and you also have a driveway in the back. So is there anything you or your client can do to make that a little bit better?
Yes, thank you for that question, Mr. Chairman and members of the panel. If we can zoom in a little more to that side of the garage there. There is still topography in this area, so there are some stairs there.
I see
but
the stairs, yeah.
But the walkway, absent the stairs, can certainly be permeable paving, yes.
Okay, and anything in behind, or is that difficult?
That is reinforced rebarred concrete. I have asked about that, and so that would be a difficult ask. I would say that is not an area that could be permeable.
I understand. All right, thank you for that.
You're welcome.
Okay, we're back in committee.
Okay, I think that's a reasonable ask. That would be an improvement. Since I've taken the lead on this one, for some reason or another, I'll put forward a motion to approve it, to approve the application with the condition that the rear walkway adjacent to the garage be constructed using permeable pavers. Is that sufficiently clear, Secretary Treasurer? I see her nodding, so that's my motion.
Okay.
Through you, Mr. Chair, yes.
There are no other conditions. So, motion by Mr. Ghosh to approve with that condition, second by Mr. Bissonnette. All in favor? You have your approval. Thank you all. Thank you all for coming down. We go to 18 this morning or this afternoon, Sabrina? What's our
Through you,
cutoff?
Mr. Chair, we go up to item 16.
16. So we have 3 more guys. Can we just plow through these?
Yep.
Okay. Okay, number 14 is 356 Huron. This is an application to convert the existing 2-story detached main dwelling into a mixed-use building through interior alterations to permit a restaurant with use within the ground floor of the building. Also to construct a new 2-story detached ancillary building containing 1 laneway suite with bedrooms within the basement below and the rear yard abutting the public laneway. There'll be a total of 2 residential dwelling units on this lot. Committee has 4, a copy of plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, covering letter from the agent. We have email correspondence from Transportation Review and from Urban Forestry.
Through you, Mr. Chair, we have the agent online, and there are no other registered speakers for this item.
Okay, Mr. Galbraith.
Good afternoon.
For the record, sir, name and address.
Sean Galbraith, planner here on behalf of the application, 18 King Street East, Suite 1400, Toronto.
All right. Hang on a sec, sir. Panel, does anyone need a presentation on this one? Want to go straight to questions? Sean, we don't need a presentation today. We've read the application, obviously. We understand what's before us. we don't really need a presentation. We may have questions.
Happy to answer them.
Is there anything you want to share with us before we do that?
So this is, I think this is a fairly straightforward one. The reason why we have this application today is basically because the entire St. George campus of the city of the University of Toronto is not subject to the current zoning bylaw. It's still under 43886. Nonetheless, my clients designed the proposed laneway suite to be entirely in compliance with the current laneway suite provision. So we think that it would not trigger any variances should the bylaw have been updated. And the proposed, there's no external construction proposed for the existing two-story building out front. The only thing that's proposed is the change in use to commercial on the ground floor. The property is currently used as the office for the applicant. So there's no existing residential tenant in the building. So no one would be displaced. It was always designed with this use in mind. And the current changes to the St. George master plan contemplate mixed-use buildings in residential zoned properties, just like this, and just like what was done at 364 Huron, two properties away, a project that I also worked on.
Okay, yeah, it looks like a reasonable approach, or application. Just variance number 6, what's with the 33-meter depth?
Give me a sec here. Oh, so that's because the laneway suite is not permitted under the old bylaw. So it's measuring basically the two buildings as one.
Ah, okay.
Yeah, under the laneway suites bylaw, that was addressed, that the ancillary building doesn't count towards the building length.
Okay.
But because we're still under 438, it does.
All right, questions?
It's a weird one.
Ryan?
The laneway suite will be residential for rent?
Yes, sir.
Do you know?
Standard laneway suite.
Thank you. Good afternoon, Mr. Galbraith. I can't see
Hello.
on the screen. I hope you're wearing your signature bow tie.
It's casual Wednesday here at home.
If you don't know, people don't know, Mr. Galbraith has a great, I think one of the best collections of bow ties in the city.
Thank
If you
you.
like bow ties.
Yeah.
I do. I kind of
So the small-scale non-residential component of this mixed use, it's a consideration that would be part of the city's recently adopted OPA 612, Neighborhood Retail and Service Study.
This was proposed, and we first started talking with this with staff about this one in 2022. So this sort of, the concept for this predates the current retail, current retail OPA.
Yep.
I would say it sort of supports it, but I would say it more supports the specific secondary plan for the U of T campus.
Right. No, I agree with you. And I know this area well. I spent many bleary-eyed nights at Robarts while I was at U of T. So I'm.
And this being right across
yeah.
from that, I think it would well service it.
I will be supporting this. Thank you.
Thank you.
Any further questions? Okay. Let's take it into committee.
So, I mean, this is essentially on U of T campus, and, I'm also a proud alumni who also spent countless hours at Robarts Library. And, I wish I had more cafe options when I was being studious, so I find this supportable, and I'm happy to put forward a motion. I don't think I saw conditions. No conditions.
There's forestry condition number 2.
There is 4. Oh, so, okay, so, motion to approve the forestry condition number 2.
Okay, motion by Mr. Bissonnette to approve with forestry conditions, seconded by Mr. Lombardi. All in favor? You have your approval, thank you. Okay. Move on to item number 15, 18 High Park Boulevard. This is an application to construct a new in-ground swimming pool in the rear yard abutting the west side of the lot. The existing two-story detached dwelling will be maintained and unaltered. The committee has before it a copy of the plan of survey, site plan, floor plans. Copy of plan of survey and site plan. No floor plans, obviously. 3 photographs of the subject property. We have staff report from Urban Forestry. We have a 9-signature petition in support from owners occupants on High Park Boulevard and Sunnyside Avenue.
Through you, Mr. Chair, we have the agent here in person to speak, and we have one registered speaker also here in person.
Okay. Good afternoon.
Good afternoon, Mr. Chair. I'm Trevor Gain. I'm the agent here on behalf of the owners.
You've been here for a while, sir.
Yeah. I need to revisit my life choices, I think.
We have someone speaking on this item, so we're going to need a short presentation.
Sure. As you described, this is a pool, so just basically a landscaping issue. If we can pull up the site plan, the existing dwelling is kind of an L-shaped house, if you scroll down a little bit. So the red outline is basically the backyard. That's pretty much where the area of the pool can go. So if we complied with the bylaw, one, there's a protected tree that's in the way if we slide the pool to the right on that diagram. And if we slide the pool southward, downwards, it starts to get into the parking and it starts to split up the backyard a little bit. So the pool is designed to keep with the bylaw 1.2 meter setbacks from the property lines as if this was just a regular mid-block house. And unfortunately, due to the existing house, the tree, the pavers, the existing landscaping, the variances are being sought.
Okay. And there is a forestry condition, right?
Yeah, that one tree in the top corner is being injured, and it's actually an improvement because the backyard is overpaved as it is, so there's a whole bunch of hardscape that's going to be cut out and replaced with soft. Thus, we have no landscape variances.
Okay. All right. We do have someone here to speak. Here? Okay. Good afternoon, sir.
Good afternoon. I'm Andrew Gonzalez here for 295 Sunnyside Avenue. Thank you everyone for your time today. Wanted to touch base on the variances with respect to this. I know that the owner of both 295 Sunnyside as well as 18 High Park have been in communication to see how we can ultimately come to an amicable proposal on how to proceed, as we would love to see the family proceed with their pool. But we just do have some concerns regarding the variances, regarding the dimensions that were mentioned with that. So ultimately, I'm here to ask the Honorable Committee just to see if there are any concerns that are raised and just to address some of the concerns that we have with respect to this. So I do see that first variance that was mentioned references that the bylaw, there's a distance required of 3 meters. Noted with things regarding the reasoning on the protected tree as well as the driveway interfering on the south side. And I see that with respect to what the owner's trying to do is bring that down to less than half, to about 1.22 meters. Our concern ultimately comes with the fact that 18 High Park is at a more elevated position than 295 Sunnyside. Not only that, but towards the back of our property at 295 Sunnyside, it continues to go at a lower elevated position. And with this, we have concerns of water overflowing or any drainage issues that may come about as a result of the difference in elevation between 295 Sunnyside and the surrounding properties around the area. Yeah, so ultimately it's a concern of drainage issues. We've had water runoff onto the driveway of 295 Sunnyside. With the winter coming up, there's ice buildup. We've had damages, unfortunately, with flooding in the basement. So ultimately, it's a concern of the elevation amongst the two properties. We believe that this could be mitigated if the leveling of 18 High Park was leveled to be flat, to be more in line in lieu of the current elevation that's in place. With respect to the paperwork that was presented on the website or during the presentation, we do note that there's a couple of signatures of no objection from the community members on Sunnyside as well as High Park. On that note, right, us being directly north of 18 High Park, we're the property that is right next to it and ultimately right next to where the swimming pool is being proposed as well. In addition to that, if you reference the site plan that was given near the middle left, it references that there's a wooden fence that's within the bylaws. Right next to that fence, there's also a chain fence that is amongst the perimeter between the two properties. And again, the owners of both 295 Sunnyside and 18 High Park have discussed this. But that chain fence on the north side facing our shared perimeter is about 9 feet tall, and we understand that to be outside of the bylaw requirements by the city of Toronto. I do have some visual aids. Unfortunately, we weren't able to upload them within the time required, so I have the visual aids if you're willing to accept it.
Unfortunately, we can't, I'm sorry.
Okay, but if not, essentially to conclude, our concern with everything is, one, about the elevation and potential drainage concerns that we would have. And again, we're willing to work with the owner of High Park to come to a resolution there. It's a concern of the elevation, as well as what I referenced of that chain link fence being about 9 feet tall outside of bylaw requirements.
Okay, thank you, sir. I'm
Thank you.
just looking, I mean, what's the grade difference between your property and this one? I mean, Google Maps and Google Street
Yeah.
View is sometimes deceptive, and I'll acknowledge that, but I'm just looking at your property, your client's property, and subject property, and it sure doesn't look like there's much of a grade change. Is there one? Do you have a sense of what the difference would be?
I have an image. In terms of like specifications in a number, I wouldn't know. I do have images here with me.
Sabrina, I don't think we can accept those,
Okay.
right? No, I'm sorry. So, but your view, I will ask the agent the same
Mhm.
question, but your contention is that there is a significant grade change and you're concerned about?
Yes,
this
drainage
pool being
concerns.
Drainage concerns,
Sure,
okay.
or overflowing. I mean, I know the pictures are there. From their side of the property, I of course have some from mine, but like visually looking at, or like as you mentioned from Google Maps, there's that difference in elevation. Our concern is any drainage issues.
All right.
Thank you very much.
All right, panel, any questions of the speaker? I see none. Thank you very much, sir. Mr. Gain?
Thank you, Mr. Chair. Can we bring up the survey? This is going to address the spot elevation. So if we zoom right in on the top, there's 2 spot elevations on either side of the fence, and that'll give you your answer. There's like 98.18, I think, is on the neighboring side, and then just below that, there's another 98.42. So there's a 30 centimeters difference between the 2 properties.
Okay.
So that's what it is. Just regarding drainage, obviously, with any property, any development, any building in City of Toronto, you got to contain your water. So our intent is not to raise this grade. We'll just control the drainage. So if there is water that's spilling on the driveway here and there, it's an old property that's probably not been in check, but here's a chance now that we can address it and redirect the grading back onto our property or into the existing swales. So there's no intent to damage the neighbor's property. It's just a pool. The fence, I guess there's a very tall chain link fence there, again, existing from numerous years. Subject to the outcome of this hearing, we have to go through a pool enclosure permit, and we have to deal with the fence bylaw. So whatever the fence requires heights, whether it's transparent, opaque, operable, typical stuff for a pool, we got to go through that process, and we can address the fences at that time. I believe signatures report, the neighboring, it is a rental property. The owner wasn't there. We did talk to the neighbors or the tenants, and they didn't really have any concerns, nor did they want to sign on behalf of the owners. But we did go around the neighborhood and try to just make sure everybody understood what was going on. And like I said, it's just a simple pool. Unfortunately, due to the location and the house and the tree, we're here today.
Okay. Thank you, sir. Dina, do you have a question?
Just 2 quick ones. This is a corner lot, I know. I'm not a pool person. I don't have a pool at my property, but it seems like a strange place to put the pool. I mean, I know that it's constrained in a way with the large home, but there's no place for landscaping, because usually when you put a pool in, you like landscaping and privacy.
Right. You're exactly right. Like, it's a tiny little spot. So there's a little bit of coping that goes around the pool, and you can see the fence enclosure, which would be hard.
Yeah.
And then we have some existing parking, and then a lot of the hardscape will be pulled off and replaced with soft. So it's just a small little fiberglass pool. Looks like, given the size, they drop in, and it's just for the amenity of their family.
And Follow-up question. I'm glad you you mentioned parking. The existing driveway, so is there going to be parking as there is today? There's a parking area?
Yeah, we have to maintain the parking. So right now, it's all kind of paved erratically, and they just park wherever they want. So now they'll maintain a strip, push the parking closer to the boundary line on the west side, and then they can, where it says soft landscape, and that'll be hardscape brought back to soft.
Okay, thank you.
Okay. Anyone else? Okay, thank you very much. We're in committee. Phil?
Interesting point our colleague Mr. Lombardi made. It's odd to have parking between your home and a pool, but I don't see that as anything that affects the variances. I think it makes sense to have these variances to have the pool be minimally impacting on the existing tree, which seems to be one of the large reasons of moving it to in a way that reduces these setbacks. So I see no reason not to approve the variances that allow the pool to be located in this way, especially on a corner lot.
So just make the point that they've actually dramatically improved the soft landscaping as well. Right?
Exactly. That's a good point as well. So I'll just move to approve it, subject to forestry number 2.
Okay, motion by Mr. Ghosh to approve, seconded by Mr. Lombardi. All in favor? You have your approval. Thank you.
Merry Christmas, everyone.
Thank you. Same to you. Okay, and that concludes the morning session.
Nope.
Sabrina,
Through
we're
you.
back at...
No,
No,
we have
one
one
more.
more.
Oh, I'm sorry. Oh, right, I thought that was 16. My apologies. Okay. Item number 16, 244 Virginia Avenue. This is an application to construct a new 3-story detached residential building containing 6 residential dwelling units with 3 partially covered front porches and stairs, 3 partially covered rear decks with stairs, 2 rear second floor bay windows, 3 third floor rooftop, front rooftop decks, and 3 rear basement walkouts. Also to construct a new front driveway with 2 parking spaces, the existing front driveway with 1 parking pad, and the existing rear driveway and 1-car garage will be maintained and unaltered. Committee has before it a copy of plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, covering letter from the agent, and a copy of the front yard parking agreement affecting the subject property. We have email correspondence from Transportation Review. And is this Mr. Galbraith again?
Through you, Mr. Chair, we have the agent online to speak, and there are no registered speakers, no other registered speakers for this item.
It is. Mr. Galbraith.
Hello again.
For the record, sir.
Sean Galbraith, Pioneer here on behalf of the application, 18 King Street East, Suite 1400, Toronto.
Okay, this is actually quite an interesting one.
It is.
Personally, I thought it was a pretty creative way to use a very unusually shaped lot.
I thought so too.
To introduce, some good housing stock. I thought it was quite creative. As a consequence, I'm just going to say, does anyone need a presentation on this one? Because I thought it was, the presentation material was really good and very straightforward, and I think it's a good proposal. So no one needs a presentation. Sean, you've heard that. We don't need a presentation. Is there anything you'd like to share with the committee before we take it in for a decision?
No, sir. But if you wanted to do permeable pavers on the 2 new parking spaces, we are happy to do them.
You've been listening to us this morning.
It's not my first time. And then other than that, I just wanted to say happy holidays and congratulations to getting to the last agenda of 2025.
Thank you very much. It's been a full year, and that congratulations goes straight to staff. They're doing all the hard work.
Very much so.
All right. Any questions on this application? So you've stunned us into silence, sir. Let's take it into committee. Who wants this one? Dino?
Thank you, Mr. Chair, and happy holidays to you too. Yeah, I know this property, and I think that it's an appropriately designed development for the location, and I think the variances that are being requested individually and cumulatively meet or satisfy the 4 statutory tests. I also think it represents good community planning, especially in this area, and I agree that the proposed design is appropriately scaled for the context. So I'm prepared to move a motion to approve the application and grant the variances being requested. And I note that the city obviously recently approved as of right 6 plexus in Toronto, East York, and Ward 23 in Scarborough. That's OPA 762 and 818 and all the other OPAs that have come down over the last month. So I'm prepared to move a motion.
The agent very kindly offered to introduce permeable pavers, and I hate to not take an agent up on those offers. So would you like to have permeable pavers for the driveways?
Absolutely.
Okay.
If it's being offered, I absolutely will accept that.
All right.
On behalf of this committee.
Okay, motion to approve with that condition, Mr. Lombardi.
If I might make a comment as I second.
Sure, by all means.
I just also want to say that it's a creative use of the 6-plex regulations, and I think it demonstrates well what's possible, and hopefully a sign of the future.
100%,
yeah.
agree. Okay, seconded by Mr. Ghosh, all in favor? You have your approval, sir, thank you very much. Now, that's our last one, right?
Yeah.
Through you, Mr. Chair, we'll be back at 2:30.
Just for the members' edification, that's an extra 7 minutes beyond what we usually get.
Second donut.